Good morning. Today is Thursday, August 25th. This is the time and place regularly scheduled the Navigating Commission meeting for the month of August. Please rise and join us in the
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary.
How about that? Madam Secretary, has our agenda been posted in accordance with the open meeting law?
Yes, it has.
All right, at this time, I would like to remind anyone coming to the podium to speak, we ask that you speak directly into the microphone and speak clearly as possible, as this meeting is being transmitted electronically and transcribed. Madam Secretary, let's proceed, if we could, with our first agenda item, public comments.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters.
Okay, anyone who wishes to address the commission may do so at this time. Matters brought to our attention during public comment cannot be acted upon, but we're happy to hear comments from the public, as well as my fellow commissioners. Comments by all will be limited to 3 minutes as a reasonable time, place, and manner restriction. If any of my fellow commissioner or myself asked questions of you, any of you, the time needed to address those questions will not be held against those time constraints. I am going to start in Carson City though first, and as I always do, and see if there's anyone present in Carson City who wishes to make a public comment. It appears there is not. Okay, from Las Vegas, sir, could you please state your name for the record?
My name is Henry Anthony Joyner.
Thank you.
Good morning. My name is Henry Anthony Joyner. I've been working as a cook at the Red Rock Casino for 5 years. I made a public comment in front of the Gaming Control Board in June of this year. This is what I told them. I'm a hardworking hourly team member, and I am dedicated to my job. I want to keep working for many more years. I'm also a dedicated union leader. I am fighting for a union contract at the Red Rock Casino because I want myself and other hourly team members to enjoy fair wages, good health benefits, and fair labor practices. I work one job, and one job should be enough. Having a union means having safety, security, and dignity. As a worker, I want to ensure a union standard for myself and my fellow co-workers. Thank you.
Thank you.
Hi, good morning.
Good morning.
Mi nombre es Marta Jara. He trabajado para Santa Fe Station durante 14 años en el departamento de Internal Maintenance como casino por. Hablé frente a esta comisión en junio de este año. Les conté que hemos estado luchando durante más de 12 años para tener un sindicato en Stations Casinos, porque necesitamos un sindicato para que seamos representados por la compañía. Estoy aquí hoy para decirles de nuevo, queremos un seguro fijo que no se modifique a conveniencia de la compañía. Queremos el derecho a aumento salarial cada año. Queremos un contrato que nos proteja y que la compañía cumpla con nosotros. Queremos que mis compañeros de trabajo de Stations, de Texas Stations, Fiesta Rancho, Fiesta Henderson y todos los buffets cerrados también tengan derecho a regresar a trabajar, respetado por Stations Casinos. Gracias.
Thank you.
And then I'm going to read that in English. So my name is Martha Hara. I have worked for Santa Fe Station for 14 years in the internal maintenance department as a casino porter. I spoke in front of this commission in June of this year. I told you about how we've been fighting for over 12 years in order to have a union at station casinos. We need a union because we need to be respected by the company. I am here today to tell you again.
Miss,
We want set insurance. Yes?
you can speak at a normal rate. If it's the
It's
same
not
exact
the same.
statement, I'm not going to.
Got it.
Okay,
Okay. We want set insurance that's not changed at the company's convenience. We want the right for wage increases every year. We want a contract that protects us and for the company to comply with us. I want my coworkers from Texas Station, Fiesta Rancho, Fiesta Henderson, and all the closed buffets to have their right to return to work respected by station casinos as well. Thank you.
thank you. And the record should reflect, we've been given a written copy of what was just read to us, correct?
Correct.
Good morning. My name is Isabel. My name is Isabel Saldana. I work as cook at Boulder Station for 23 years. I work hard at my job to support my 3 children, a single mother, but the company keeps pushing us to work harder and harder. Since the pandemic, we have been under fire in the kitchen. I feel like I'm doing the work of multiple people. Many of my co-workers have been laid off and not bringing back to work. And with Texas Station, Fiesta Rancho, and Fiesta Henderson closing permanently, what will happen to these workers? Want them to return to work as well. I want to stay in my job. I don't want my job to get harder. We are fighting for union and station casinos to be respect our workers. Thank you.
Thank you.
Good morning, Gaming Commission members. I'm Ted Papageorge, Secretary Treasurer of Culinary Union Local 226. 5 months ago, I submitted a letter to Nevada gaming regulators about station casinos and made our position very clear. We believe regulators should regulate, and that means investigating station casinos and taking disciplinary action. Since that letter was submitted, stations casinos workers have come to every Nevada Gaming Control and Gaming Commission meeting to tell you why you need to act. They've not missed a meeting, and they've told you how bad station casinos treats the workers that run the industry that you regulate. So I'm here today with station casino workers to get some answers. Frankly, station casinos workers and all gaming industry workers in Nevada have a right to know whether or not a state regulators have the power to discipline bad actors like stations casinos. And if you can't act here and are powerless, we want you to tell us. And by all means, if you're powerless here, tell us what we can do to give you the powers to hold bad actors like station casinos accountable. Station casinos has a huge footprint in this valley, and their actions have a wide reach in our community. So we all suffer when they are not held accountable. We owe station casinos workers so much because they've dug in. And they stood up to this company time and time again. Workers are holding stations accountable, and frankly, you need to do the same thing too. If you're not able to hold stations accountable, please tell us. If license holders can do what stations did during the pandemic and is doing now, and you're not sure what you can do, tell that to the workers. We think working people and working class voters are owed some answers. Thank you.
Anyone else wishing to make any public comment? All right. That will close our public comment section. At this time, Madam Secretary, the next item on our agenda is the approval of the prior month's disposition.
Pursuant to NRS 241.035, this item is the consideration of the approval of the Nevada Gaming Commission disposition for July 2022.
Okay, I think each of us has had the opportunity to review the prior month's disposition. If there are no questions or comments, I think it's in proper form for a motion.
Thank you, Chair Tagliati. I move for approval of the prior month's disposition as read into the record.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
And it appears there are none opposed. Thank you. Madam Secretary, please read in the non-restricted consent items.
Your items on the non-restricted consent agenda this morning are items 5, 6, and 8. The recommendation of the Nevada Gaming Control Board is for approval. I believe we have a disclosure and recusal on these items.
Thank you so much. Chair, if I may, for non-restricted consent item number 6, Boyd Gaming, California Hotel and Casino, and Coast Casinos, Inc. are adverse to current clients of Louis Roca, the firm where I'm a partner, in an unrelated matter in which I am not personally involved. I have no pecuniary interest in the outcome of this agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate.
Thank you.
Thank you.
Thank you, Madam Chair. As it relates to non-restricted items number 5 and 6, those are items where the gaming counsel is being provided by attorneys at the law firm of McDonald Carano, where I am an employee. And because of this pre-existing relationship, I need to recuse myself from participating on those specific items. I can, however, participate on item 8. Thank you.
All right, thank you. So with those disclosures, is there, perhaps we separate the consent items and just handle 5 and 6 without Commissioner Keycapper? Does anyone have a motion as to those 2 items?
Yes, I would move for approval of non-restricted items number 5 and 6 is read into the record by Madam Secretary and recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor say aye.
Aye.
All right, it appears there are none opposed and Commissioner Keycapper did not participate in the vote. As far as item number 8, does anyone have a motion?
I move for approval of non-restricted item number 8 is read into the record by Madam Secretary and recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor say aye.
Aye.
And it appears there are none opposed. Thank you. Madam Secretary, please read in restricted consent items.
Your items on the restricted consent agenda this morning are items 2, 4, 5, 6, 7, and 8. The recommendation of the Gaming Control Board is for approval with the conditions as noted on the agenda. I believe we have a disclosure on these items.
Thank you. I do have a number of disclosures. Everyone's indulgence, please. Restricted item number 2, Golden Gate Petroleum of Nevada LLC and Golden Gate SCT Petroleum Partners of Nevada LLC, to the extent affiliated with the applicant appearing today, are current clients of Louis Roca, the firm where I'm a partner, in unrelated matters in which I'm not personally involved. As to consent restricted number 4, Dottie's 192 and Nevada Restaurant Services, Inc. are adverse to a current client of Louis Roca, the firm where I'm a partner, in unrelated matters in which I'm not personally involved. And as to restricted items number 5 and 8, I make this disclosure in an abundance of caution. An entity with related name, Century Games Pte. Limited, is a client of Louis Roca, the firm where I'm a partner, in an unrelated matter in which I'm not personally involved. I have no pecuniary interest in the outcome of these agenda items, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. Thank you.
Thank you. So as it relates to the consent agenda for the restricted items, does anyone have a motion?
Thank you, Chair. I would move for approval of the consent agenda items for restricted items 2, 4, 5, 6, 7, and 8 as recommended by the Gaming Control Board.
All right, is there any discussion on the motion? There being none, all in favor, say aye.
Aye.
And it appears there are none opposed. Thank you. Madam Secretary, please read in the new game consent item.
You have one item on the new game consent agenda. That item is new Pan 9 submitted by Scientific Games Corporation.
Okay. Is there any discussion on this item that anyone wishes to make or any comments? All right, there being none, is there a motion?
Chair Tagliati, I move for approval of the new game, new Pan 9, as recommended by the Gaming Control Board.
Okay, any discussion on the motion?
Just for clarity of the record, for the transcriber, the word for new Pan 9, it's N as in Nancy, the number 9, N and E. It's a different spelling, just so that it's clear for the transcript.
Okay. All in favor?
Aye.
Aye. And there are none opposed. Thank you. All right, this is non-restricted items held up for discussion. Madam Secretary, could you please read in non-restricted number 1? Number 2, excuse me. Almost caught it.
Non-restricted number 2 is the application of Flutter Entertainment PLC for registration as a publicly traded corporation and for finding of suitability as sole shareholder of Betfair Group Limited. It is also the applications of Betfair Group Limited, the Sporting Exchange Limited, TSE Holdings Limited, Fanduel Group Parent LLC, and Fanduel Group Inc. for registration as an intermediary company and finding of suitability as sole shareholder, managing member, and/or sole member as noted on the agenda. Also included is the application of Betfair Interactive US LLC doing business as FanDuel Sportsbook for licensure as a manufacturer and distributor and as an information service, and to receive a percentage of gaming revenue from Sam Will Inc. with conditions as noted on the agenda. It is also the applications of Jeremy Jackson, Jonathan Hill, Gary McGann, Paul Cutter, Edward Trainor, Amy Howe, and Andrew Giancamilli for a finding of suitability and/or licensure as officers, directors, and/or key executives as noted on the agenda. I believe we have a disclosure on this item.
I do, thank you. For Boyd Gaming is adverse to a number of current clients of Louis Roca, the firm where I'm a partner, in unrelated matters in which matters I'm not personally involved, with the exception of one litigation matter in which I'm involved as local counsel, which has recently settled and is subject to court approval in state court in the 8th Judicial District Court. I have no pecuniary interest in the outcome of this agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationships described on the record, and I therefore intend to participate. Thank you.
Thank you, Madam Chair. I also need to make a disclosure on this item. I'm an employee of the law firm McDonald Carano. McDonald Carano serves as gaming counsel for Boyd Gaming Corp., but Boyd does not have applications before us related to this agenda item. I have no pecuniary interest in the outcome of this item, and I don't think my judgment is personally impacted by this relationship. So I'm prepared to participate.
Thank you. Morning.
Good morning, Chair Tagliati, Commissioners. For the record, I am Erica Okerberg. I am outside Nevada Gaming Counsel to the company. Here with me today are the individual applicants who are named on the agenda, as well as legal counsel Allison Meyer. I understand the commissioners, of course, have had an opportunity to review the report and either watch the board meeting or the transcript. So what we would like to do is provide a slightly abbreviated presentation for you today. That would consist of me providing an abbreviated overview of the applications. We would provide a company presentation in the form of a PowerPoint. And then if you'd like, we could have the individuals come up and introduce themselves as we did at the board meeting. If that's acceptable, I'll proceed with the applications.
Thank you.
Wonderful, thank you. So as discussed at the board meeting, the primary applicant that's before you is Betfair Interactive US LLC, which does business as Fanduel. Fanduel has applied for licensure as the operator of an information service, a manufacturer, and a distributor, as well as approval to share in gaming revenue from the sportsbook at the Fremont Hotel and Casino. I'd like to make a few notes for the record as far as the information service license is concerned. First, there are no immediate plans for Fanduel to deploy any technology in Nevada. Of course, if that were to change, we would meet with the board's technology division and seek approval for that technology. The retail sportsbook platform at the Fremont Hotel is currently an IGT product, and the plan is that it would be an upgraded IGT product with some specifications made going forward. Fremont will continue to operate the book. It will set its own lines and odds. It will make its own decisions regarding risk management using its own risk traders and its own risk desk. Fanduel will provide a line and odds feed and then advice and guidance on how to set lines and odds and how to manage risk. So in sum, the Fremont will continue to operate the sportsbook pursuant to its sports pool license. Fanduel will provide a line and odds feed and advice and guidance, and will share in gaming revenue from the sportsbook. It also will engage in a co-branding arrangement with the Fremont for purposes of the sportsbook. With those introductory remarks, I'm happy to answer any questions. Otherwise, we could proceed to the company presentation.
Does anybody have any immediate questions?
Wonderful, thank you.
I'll raise my question, and whether you want to address it now or later on. It'll be a Fanduel branded sportsbook, with Fanduel aiding Boyd, if you will, with the lines that are posted but Boyd is not locked into those lines.
That's exactly correct. Boyd can make its own decisions.
Now, typically from a patron standpoint, like parlay cards.
Mhm.
Parlay cards typically, whether it's Boyd or, one with multiple properties, will say at the bottom of the legend, the different properties. Is there the possibility that the Fremont branding with Fanduel will have a separate independent parlay card with separate independent lines, different than all the other sports books under the Boyd umbrella?
In theory, that's possible. I think it's certainly something that they would have to think about and understand from a business perspective. But I think in all cases, it would be clear to the patron whether they're wagering with the Fremont or with one of the other properties, that it's either a Boyd product or a Boyd Fanduel co-branded product.
So that's what I'm getting at. I mean, I have no issues with what's going on. I just have an issue with, is there going to be confusion to, John or Mary Doe in wagering on, well, wait a minute, over at the Fremont, over at, the Orleans, type of thing. It's different than here. Why is that? So I just want to make sure that the patron understands that it's a Boyd card, but it's a branding. So that's internal purpose, but I wanted to raise that issue. I appreciate that.
Absolutely. Thank you. All right. Well, if acceptable, then we will start with the company presentation. And first, I'd like to have Peter Jackson come up to begin.
Thank you.
Jackson.
Good morning, Chair and Commissioners. Just a point of clarification for you. I'm known by my middle name, which is why Erica refers to me as Peter, and the application has me down as Jeremy. There was a slightly strange family tradition, which we've now ceased because it causes lots of confusion. I'll take you through our brief presentation this morning, which I think will provide some context for where Fanduel fits into the Flutter organization. You can see on this first chart, we are the world's largest online gaming and sports betting business, and we have locations all over the world. On the next chart, the leadership of the board is Gary McGann is here, and you'll meet Gary shortly. Our board is diverse. We have nearly 43% of the board made up of females and 57% male, and there's a lot of experience sat around our board table. We are a dual listed UK-Irish business. If you look at page 5, you can see how my team is organized. I'm the chief executive, and I have 4 divisions, which effectively are organized and grouped around different geographies. So Amy, who we'll meet shortly, runs our business here in America. Barney Evans runs our business in Australia, which trades under the Sportsbet brand. Connor Grant runs our business in the UK and Ireland. And Dan Taylor runs what we describe as our international business, which is all of the rest of the world from our perspective. And then Jonathan Hill, our Chief Financial Officer, and then Paul Cutter, you'll also meet, who's our CIO. And then finally, I have Podrick Arid, who's my Chief Legal Officer and Commercial Director. The next page shows how the business trades and the different brands that we use. So you'll have heard reference to our application, the Betfair brand, which is a brand that we use predominantly in the UK and Ireland and in some countries in our international division. You can also see the other brands that we trade under. Using the sporting vernacular, we describe ourselves as having gold medal positions in a number of these markets, by which we mean we're the largest player in the UK and Ireland, in Australia, in a number of markets in the international segment, and also here in the US as well. Jonathan, do you want to come up and talk about the financials?
Chair, Commissioners, good morning. I'm Jonathan Hill. I'm the Chief Financial Officer for Flutter Entertainment PLC. So I'll just start you on the top left-hand side. We're a pretty diversified global business with just over a third of our revenues in the first half of the year coming from the US, third from the UK, and then a split between Australia and rest of world. We currently trade with a market cap of around $23 billion. We've suddenly had a slight increase in our share price given our positive sports results, which I know Amy will talk to you about in the US and our improving performance in the US business in the first half of the year, and particularly in the second quarter of the year. Our revenues are just over $7 billion globally, and our EBITDA, excluding US, is just around $1.4 billion. We've got 20,000 employees spread. I think the map earlier showed you they're spread quite a lot across the world in various jurisdictions. Underpinning everything we do is about having a safe, responsible, and sustainable way of operating as a business. I know Peter will talk to you later about our positive impact plan and what we're trying to do to ensure that our customers remain safe as a priority, as the core of our positive impact plan. We are a very innovative business with very distinctive brands, often in the markets which they are the market leader, and they are known synonymous with that country and that in this business. And we also have a lot of proprietary technology, proprietary IP, particularly around our pricing as well as our product generation. So I'll just flick on to the next slide. So just on the left-hand side of this slide, you can see the H1 2022 revenues for Fanduel, $1.3 billion, up significantly year on year, 56% up year on year from $843 million. And you can see there against the competitor set in the industry, we are by some distance the largest generator of net gaming revenue across the US, across the category of sports betting and gaming. And you'll see on the right-hand side, we are predominantly the gold medal holder, going back to sports vernacular again, which Peter used in I think on this chart, on 14 out of the 15 markets in which we operate. You know, we're very pleased with where we've ended up in terms of our market share, in terms of our positioning in the US.
Mr. Hill, may I interject for just one moment?
Sure.
Going back to your prior slide, how many of the 20,000 employees are in the US and how many of those are in Nevada?
We have roughly 2,600. In the US, we have the US division has about 2,600, and I don't believe we have any in Nevada right now.
Thank you.
Yeah, at this point, I'll hand back to Peter.
Thank you. This chart lays out our group strategy, which is another way of trying to articulate the direction we're taking the business. And you can see we have three major objectives. First of all, to grow our gold medal positions in our core markets. In other words, we want to keep growing in our markets in the UK, Ireland, Australia. Secondly, we want to invest substantial sums to continue to win in America. We've been very fortunate since we saw the PASPA being repealed on the 14th of May, that we've been able to invest resources, bring talent and capabilities into the US market, and stood us in good stead, together with our historical investments in the US. And then finally, to build on our network and invest for leadership positions across international markets. So we recently concluded the acquisition of a business in Italy, which will give us the #1 position in that regulated market. And then we also want to take early positions to realize potential in future spaces. And by that, we want to be thoughtful about identifying opportunities in areas like esports, the metaverse, and other areas which we think in the next 5 to 10 years could become important for our industry around the world. You can see that we have a number of key enablers that we believe supports the strength of our business. We think our scale is important. That's both on a national basis, but also internationally. We like to think we can move nimbly and quickly. So we would say that we have the sort of the mindset of a challenger at the scale of the leader. Our products and technology that Paul is responsible for in terms of setting the direction for that is very important, which allows us to move quickly and deliver great products to our customers. And then finally, we want to use the insights and data we get from our customers to ensure we're delivering them the right products. The most important component, though, of our enablers is what we describe as our positive impact plan. And I can talk to you a little bit more about that on the next page. This has been an opportunity for us to pull together a lot of the great work we do across our business in three major areas. First of all, how we're helping our customers to play well. Secondly, empowering our colleagues to work better. And then finally, working with our communities to do more. We've identified, there's a lot of work we've been doing in these areas, and we felt we were not putting enough emphasis into communications around what we've done. And so we've started pulling that together into what we describe as our positive impact plan. And there's been a additional sort of, disclosure we've made around that. It's part of our annual report, and we'll report against some targets we've set ourselves. And the next page lays out those targets. So you can see that under our Play Well, we want to have 75% of our customers using Play Well tool by 2030. We think that sustainable play is very important, and we've been real pioneers in terms of our approach to responsible wagering in the markets in which we operate around the world. Secondly, we want to work better. We want to create and build teams that are representative of the locations in which we live and work by 2030. We have a comprehensive DE&I strategy supported by clear stepping stone goals. As a very international business in all the locations we're in, I think that's very important. And we want to have 40% of our top leadership roles to be held by women by the end of 2026. And then in the do more area, we want to improve the lives of 10 million people using the power of sport and play, the skills of our colleagues and the reach of our brands by 2030. And as a business which is a sort of which has a large dependency on sort of online, our environmental footprint is not as substantial as a lot of other businesses, but it's still very important for us. And you can see here our emphasis on having net zero.
If I may interject briefly, sir, I understand the goal for 2026 to have the diversity for women, and not just women, but I assume underrepresented groups. What is the percentage at this point?
I don't have the number, but I will confer with my colleagues and I'll come back to you shortly and just give you the precise details. And Amy will be able to talk to you about the situation in the US.
Thank you, sir.
Thank you, Commissioner. Okay. If are there any further questions, I'll hand over to Amy, who will talk to you about Fanduel. Okay, thank you, Chair.
Good morning, Chair and Commissioners. I'm Amy Howe, CEO of Fanduel, and so I'll spend a few minutes just going through the Fanduel's performance, and I'm happy to talk a bit more about our diversity stats. So as Jonathan alluded, Fanduel is the #1 online gaming company in North America. We just came out of Q2 with a 51% share of the online sports betting market. We have a #3 position. Right now in the US, we have 3 different offices. We have headquarters are in New York. We have an office in Los Angeles, and about a year ago, we opened an office in Atlanta, primarily to diversify our talent base, and that's been a very successful move for us. From a diversity perspective, as I mentioned, overall, we have about 2,600 employees in Fanduel in the US. Just shy of 30% are women. And if you look at underrepresented populations, we're about 35%. I'll talk a bit more about what we're doing to move the needle on both of those numbers. From a retail perspective, if you look across the US, we have about 26 different retail locations. Half of those are with Boyd, who's been a terrific partner for us. And then the other half are non-Boyd properties. And this has been an important part of our strategy, both in terms of how we partner with our market access partners, but also how we engage our online consumer. This is my leadership team. I won't walk through every person. I'm very proud of this leadership team. We have a great representation of executives who have been in the industry for many years. In fact, many of them are really responsible for the regulated environment that exists in the US today, particularly Christian Ganetsky. Andy, who is here with us, has been with the company from the very early fantasy sports days. So they have very deep pattern recognition around the industry and Fanduel specifically. But we've also brought some great subject matter experts into the organization in the last year or two in particular in the areas of technology. I just hired a new chief people officer. We have a great chief product officer who has experience in other industries. And then we have, I believe, some of the best experts in online gaming and casino, which we've been very fortunate to benefit from some of the talent from Flutter, from the broader group. This is, I put this in here because the core principles of Fanduel really drive our leadership team and our organization. And I'm very proud of the way our team represents themselves in the outside market. You know, we are very much a team-driven culture. We push each other, but it's very much a humble and hungry organization, leadership team. So I've been in a lot of organizations where they have principles, but they don't live them. This is an organization that absolutely lives them on a daily basis. And as Peter mentioned, the positive impact plan, we have taken what I think is a terrific framework and operationalized that in the US. Let me just touch briefly on some of the things we're doing in each of those three areas. As it relates to responsible gaming and play well, I'm incredibly proud to say I really believe Fanduel is leading from the front in this in the United States. And again, we have the benefit of learning from decades of more mature markets. You know, we have, if you look at my risk and compliance organization and folks who wake up every day, over 100 people that are doing this. We've enlisted gentleman like Craig Carson, who has a well-documented struggle with this, and he is an ambassador who's out there really educating young men in particular, which, you know, we know over-index in some of these issues. And we're working very closely with the leagues, right, the NFL, the NBA, because this is obviously an important topic for them. They want to protect their brand and their customers. And we invest a lot from a product and a tool perspective, making sure that when you come onto our platform, we're educating you about the importance of staying within your limits. So there's a significant amount we're doing here, and we make meaningful investments in this area. In terms of work better, as you can imagine, is one of the only female CEOs in gaming right now in the U.S. This is a topic that is very near and dear to my heart. If you look at my C-suite, 50% of the C-level executives are women. But we're doing a lot across all types of diversity. So as I mentioned, Atlanta has been a really important hub for us. We're partnered up with many organizations so that we can expand that pipeline, particularly for people of color. And just this couple months ago, we sponsored Pride events across all of our different offices. So the numbers are what they are right now, but we're doing a number of things to make sure that we can make meaningful progress against all types of diversity. And then on the community front, as Peter said, this is something that we're embracing globally, but we operationalize it locally. We just had a community service day a few weeks ago, where we had an opportunity within each of our local offices to give back. And it's an important part to how we attract employees. The younger generation in particular really cares about this. They want to work with a company that cares and gives back to the community. So we're doing some great things on that front too. And I won't go through this in detail.
If I may interrupt just briefly, could you just highlight some things that you're doing with the community that you're proud of? If you could take a moment just to do that.
Yeah, happy to. So when we did this summer service day in New York, Atlanta, and Los Angeles, we partnered with each of the local communities. So in LA, I went to the local food bank, and we probably spent 3 or 4 hours working with each of those communities. And it was a great way to engage our employees, but also make sure that we're acknowledging some of the important causes within each of our local offices. And then, we typically are making donations to different local charities that may vary depending on, some of these are causes that are important to some of our employees. So those may vary from year to year. But as I mentioned, it's a really important part of how our employees make decisions about who they want to work for.
Thank you.
So switching gears, in terms of our partnership with Boyd, I think Erica did a very good job of talking through how this is going to work. This obviously is going to be Fanduel branded, but run by Boyd. And we've been partnered with Boyd for many years, so I think we have very good pattern recognition around how this is going to work. And as of right now, the plan is to open the new sports book at the Fremont in late 2020. These are just a couple of visuals. We now have very good experience opening up these beautiful state-of-the-art sports books, and this is going to be yet another example of that. And then finally, also as Erica alluded, we have, and Peter mentioned as well, we have decades of experience in risk and trading and pricing, and making sure that we can provide subject matter expertise to Boyd, but at the end of the day, they're the ultimate decision maker. Happy to take questions.
I have more of a comment. I just commend you for taking this space from a leadership level and taking accountability for the DEIB initiative. It sounds like you're not just saying it, but when I ask about the numbers, they're there. And the gap between the 2026 goals and where you are now don't seem that far off. So I commend you.
Thank you so much. It really is. It's an important part of our entire leadership team. So I thank you for that.
And I think you lead by example by doing that. You're an important, member of the community. So it's good to do that.
Thanks.
Thank you.
Okay, thank you. Thank you for being here, Ms. Howe.
Thank you.
I wanted to commend you on your efforts with respect to responsible gaming. It seems like the company has taken an incredible, top-down approach that emphasizes the importance of compliance and, has committed the resources necessary to do that. I had a couple of questions. They're a little bit all over the place, but they're just things that stood out. In some of the materials that we had, it indicated that Boyd had a 5% interest, and then in other materials it said 4.5. It probably was me that missed the change, but when did that change occur and what precipitated it?
Hi, I'm Allison Meyer. I'm on the legal team at Fanduel. I think it was in October of 2021, Boyd exchanged a portion of its membership interest in the kind of Fanduel Group parent LLC in exchange for basically nil warrants that essentially give them the ability to buy back into that extra 5%. The reason for that is in some jurisdictions, 5% ownership is a licensing threshold. And so this allows them to maintain their same economic interest without triggering necessarily licensing in states where they don't have a brick and mortar business.
Okay. I was curious if that was the reason. It seemed to suggest that might have been it, but I just didn't find the connection. So thank you for that explanation. With respect to DFS, you indicated, or at least what I saw in the materials was that there's some jurisdictions that prohibit DFS, and I realize that's not Fanduel, so if somebody else needs to step up to answer that, that would be great. But you have some jurisdictions where the company prohibits individuals from participating, and then you have some where it's permitted. You have others where there's no prohibition. What's the difference between those that there's no prohibition, but you're not actively involved?
Well, for DFS specifically, and correct me if I get this wrong, but we are taking guidance from if it's regulated and we're allowed to operate legally within a state, then we will offer our daily fantasy sports product. If it's not, then we won't.
And then when do you take that next step and actually prohibit access? Because there seem to be some states that you prohibit individuals from participating and other ones where you are not actively participating, that you don't have that prohibition. So
right. So there's some states that have like affirmative regulations, and then there are some states where it's affirmatively prohibited, and then there's the states in between that don't prohibit it but haven't regulated it, and we get a legal opinion in those states as to whether we feel like it's permissible to, given that there's not a regulatory framework, but it's not prohibited.
No, I understand that. I understand that aspect of it where you operate under the legal opinions and such. My question is, and maybe it's just too, I'm looking too far into it, but in our materials, it indicated that Fanduel prohibits individuals in certain states, Hawaii, Idaho, Montana, Nevada, and Washington, from depositing or entering paid contests. There's 18 states where you operate based on the interpretation, that of the underlying state law. There's 24 that have approved it, so that's only 42 states. I'm just trying to find out what happened with the rest.
Oh, there's two states where there's an attorney general opinion. So we put that in the category of it's essentially regulated, where the attorney general has come out and said that paid fantasy sports are lawful in the state. So there's not a regulatory framework. So did that add up to the right number?
No, not yet.
6 more.
I'm still, yeah, it's still off a little bit. So
Yes.
yeah, I just, it indicated, I know you don't operate DFS in Connecticut and Louisiana, but you do other,
We do now in Louisiana, actually, recently. It's now legal on a parish by parish basis. And
Okay.
so in certain parishes where we do operate in Louisiana for DFS now.
but that was one of the examples. Like if you didn't operate in Louisiana, but it wasn't prohibited, what's the difference between, say, Nevada and Louisiana? That's what I wasn't understanding.
Oh, I'll have to look into that. I know in Connecticut it's legal, but the some of the regulatory requirements are hard to meet, and so we made a commercial decision
not to participate. Got it. Okay, thank you. That makes sense. Switching gears a little bit, in our materials, it indicated that any patron disputes would be resolved through mutual agreement by both Fanduel and Boyd. I understood from the presentation that ultimately it would be Boyd that's responsible. So I just wanted somebody to speak to that a little bit more if possible.
That's absolutely right. So Boyd will make all final decisions regarding patron disputes. The purpose for having mutual agreement is just because Fanduel may have an existing relationship with the customer. And so the idea is to make sure to include that customer element so that Boyd has the information about someone that may be from Fanduel's customer database from another state, for example. So they have additional background on the patron.
But walk me through, I mean, in the materials, it said that the dispute is reported by both parties or to both parties. Who's doing that reporting? Are we expecting the customer to be reporting it to both, or are we expecting something else?
The customer will only be expected to report it to Boyd. They won't be expected to report it to both parties. And then Boyd in its turn would report it to Fanduel, and Fanduel could provide any information they have on the patron or the matter.
Okay, that makes sense. I just wanted to make sure there wouldn't be confusion because customers may not know to report it to two different entities, even if you're co-branded.
Absolutely. And there would be no expectation that the patron would do that or have to understand that.
Okay, perfect. Thank you. That's all the questions I had at this point. I may have additional questions regarding some of the disciplinary matters, but we can hold on those.
Thank you very much. I'm curious about sort of the marketing and customer acquisition relationship between Boyd and Fanduel. Are you going to be operating under existing agreements that you have in other states? Is there something specific for the Nevada market that is going to sort of drive this endeavor? If you could just touch on that, I'd be curious.
Yeah, we typically we make joint decisions with Boyd around how much we're going to market and how that works. Typically, we'll have the opportunity to, Boyd is leveraging their database, right, to market to their consumers. But it's very much a joint partnership to make sure that we're marketing to the right consumers, but also marketing responsibly.
And do you have sort of shared ownership of some of those databases, or do they reside at each company?
You may want to comment on that. Yeah.
Yes, thank you. I expect that would not be shared ownership. They would each have individual databases. However, there would be overlap in the relationship when the patron, for example, is both a Boyd customer and a Fanduel customer. So in that case, it would be the same person would be in both databases, but the databases would not be shared.
Commissioner Brown?
I'm not sure if you have additional presentation materials or anything else. I just have a series of questions, not all connected necessarily. So if you don't mind, I'll just go through them.
Please.
And if you want to reserve time at a different point, let me know. I was looking through the materials and I kind of have a dangler that I wanted to find out about. And I understand before Flutter and Stars merged, Stars acquired Rational Group, which operated Poker Stars and Full Tilt brands. And at the time, Flutter acquired Stars Group. Poker Stars had not operated in the US since 2011. And I read in the materials that it ceased operating because charges were brought by the US Department of Justice for violations for Unlawful Internet Gambling Enforcement Act in 2006. Can somebody explain to me what came of those Department of Justice charges?
Certainly. Ed Trainor can speak to that.
Thank you so much.
Ed Trainor, Group General Counsel and Group Company Secretary. Thank you for being here today and for having us. We were very much aware, obviously, of those proceedings when we engaged in the merger with the Stars Group. Those investigations are ongoing. We've disclosed them in our annual report. And not that we have no further comment to make, but there is no material update other than what's in the public domain, which is that they continue to be investigated, but don't pose a threat to the company.
Okay, thank you. I just didn't see any finality or conclusion, so I didn't know if it was ongoing or if it was
They're,
dropped.
they're not finalized, but
Okay,
they are ongoing. But we have very, very strict disclosure obligations as a public company and have no further comment to
of
make
course.
other
just-
than what's there.
Yeah, in my materials, it was dangling, and I'm like, okay, what happened with that?
No, appreciate that. Yeah.
Cliffhanger, so to speak. And are you still on track to close the acquisition of the Sisal in Italy? Is that done?
That's complete.
Okay, and
So
when
we
did that
recently-
happen?
That we, I'm going to say, yeah,
I did not hear.
sorry, 2nd of August.
Oh, excellent. That was
4th of
August 4th.
Sorry. Yeah.
Thank you. Well, congratulations on that. There's an arbitration, I understand, that's pending in the Stars Group versus Fox Corporation's litigation. I don't know if it's finished. Is there a ruling? Are you waiting for a ruling?
Again, that's in train.
Okay.
We've commented publicly that we expect that to be in September, October
Okay,
of
thank
this
you.
year, the outcome.
All right. That's all I have. Thank you.
No problem.
I
Happy to help.
appreciate you
Thank you.
buttoning those items up for me. Wait, there's more.
Actually, you might be the right person for the questions that I have with respect to the regulatory violations. There was a report in the media in November 2021 about an investigation into Sky betting regarding promotion materials. The numbers on that were very, very high. What happened?
I will defer to Peter probably just in terms of the actual what happened. What I would say from a legal and regulatory perspective that we proactively engaged with the regulator, both on the gambling and gaming side in the UK and also the data privacy side. So the data protection commissioners in the UK to proactively engage with them to alert them to the facts that we self-reported effectively on that matter. The facts are the facts in terms of the fine and where we landed. It's a matter that's being resolved, and there was no further action taken by the Gambling Commission in the UK on it, nor was there any further action taken by the Data Protection Commissioner.
I appreciate that.
But in terms of the commercial,
It was a very unfortunate incident. So Sky Betting and Gaming was using a third party to help facilitate marketing communications, and the third party erroneously used the incorrect database, which didn't have the marketing suppressions attached to it, and so we identified it very, very quickly, and then as Ed has shared, disclosed it to all the relevant authorities, and obviously immediately stopped.
I appreciate that.
And we will be moving to a much better platform where these problems will not happen again, and it's not used anywhere else.
Okay, thank you. It seemed that it was something that you detected pretty quickly because there was none of the self-excluded customers were actually allowed to gamble. How was it detected?
We identified it and quickly shut it down.
Were these electronic marketing materials?
They
or-
were, yeah.
Okay. All right. Thank you. I appreciate that. And then this is another regulatory violation. It looked like it was under the Flutter Entertainment issue in Bonneterre. You received a substantial fine, over 2 million for violation of socially responsible
sorry,
gaming
this is in
regulations.
relation in the UK Gambling Commission.
Yes.
Yes. Exactly. That's been publicly disclosed, and we've addressed those matters.
I'd like to hear a little bit more about what happened and how you addressed them.
So
if
specifically,
you
it was
have that information.
So there were historical matters relating back to 2016 and 2015, where our processes and procedures that were in place when we completed the Paddy Power Betfair merger were not as they should be or should have been on today's standards. So on a look back basis, there were some issues that were identified, and the customer issues in that case relate to that time period.
Okay. Yeah, the date that we had was the date of the violation or informed of the violation, which was fairly recent. That's why I was surprised. You seem to have good processes in place now.
Yeah.
But it appeared to have happened in November of 2021, so that was fairly recent.
Yeah, I mean, we the way I describe it, Civ Externus, we try and engineer a race to the top in terms of improving our standards. The UK has no written constitution, as you may know, and it's similar in some of the regulation that's applied to us from a gambling perspective. So there's a degree of interpretation that has to be taken around some of the rules and principles.
Okay.
And on, as Ed described, on a look back basis, the current approach we take to managing customers who are sort of, we think are getting close to becoming problem gamblers were not the approaches we took historically, and actually the fine we ended up paying was in recognition of the changes we've made and the fact that we were not holding ourselves at high enough standard historically.
So basically, the gaming regulations that you were charged with violating were ones that there was an interpretation issue with respect to those.
That's absolutely correct.
Okay.
Yeah.
All right. Thank you. I appreciate the responses. I was just curious because, like I said, your processes now seem to be pretty substantial. And
and
you're some
overall, I
of the
would say
best
that
I've seen.
yeah, our approach is a proactive engagement with regulators to identify issues and make regulators aware of them. That's the way we behave.
Thank you so much. I don't have any other questions. If my colleagues have any.
We may need Mr. Jackson back up on this. This is a follow-up to the inquiry regarding Bonnie Terra Limited with the UK Gaming Commission. The issues with the violation of socially responsible gaming, were those self-reported by you to the UK? Was that or a result of complaints filed or a lawsuit filed by patrons?
So this is a combination of us self-reporting some issues we'd identified to the Gambling Commission. They also undertake periodic reviews of our business, in which case we often discuss challenging situations we found with them, and some issues have been reported to them. So there's a range of different issues.
And as a result of the $2.2 million fine, which is substantial, was a complaint filed by the United Kingdom Gaming Commission, or is that just a result? I don't know the regulatory framework, or is it just a stipulated fine without the necessity to go through
there's no formula that's used to determine the size of a fine. If you look historically, every time the Gambling Commission finds someone guilty of some transgression, they typically step up the level of fine, and only relatively recently someone paid a almost $20 million fine. So they have really been ramping up the pressure on companies. So this is these issues. Typically, what happens is if the Gambling Commission are in undertaking a review of our files and our processes, they'll often identify some best practices that another gaming operator is pursuing, or we'll talk to them about some changes that we are contemplating or in the process of making ourselves. And so there's a reasonable sort of open two-way dialogue. We'll often find though that there are some specific areas that have been identified through a customer getting into difficulties, a complaint, or other mechanisms that we've identified, that there are things that we've done which the Gambling Commission decide have breached some of their sort of broader regulations. And in those cases, what typically happens is we sit down and there is a discussion with the Gambling Commission, and they will levy a fine on us. But it's not a sort of multiple of revenues or anything like that. It's determined by them.
And if I could add one additional point, the process under the UKGC for issuing fines is not similar to Nevada, where there's a formal complaint that's issued and then a response. It's more the course of an audit, sort of their review. They identify issues. Of course, some issues are self-reported, and then the parties come together and decide what would be appropriate terms, which include a fine and in some cases specific remedial measures. They might require changing thresholds if it's a responsible gaming issue. They might require putting a person in place. None of those are at issue here, but those are some examples of steps that they could take.
On this particular fine, were there remedial measures?
I don't believe so.
No, there were no remedial measures we had to take to, and as I said, we are constantly evolving and improving our processes. We track and monitor 150 pieces of information around how our customers are engaging and playing with us, and that helps us identify new and differing tools and thresholds that we can use to to monitor and control customers' behavior.
The framework that was set forth in our materials is very impressive regarding, anti-money laundering, and the like with responsible gaming. I appreciate that clarification.
Just a quick question about the procedural posture of the tax assessments that were levied in Germany and Greece. My recollection from the materials is there were appeals that were filed, and I think it's gone up to the highest level in each of those jurisdictions. Has there been briefing, oral argument? What's the procedural posture?
Certainly, Mr. Hill.
And they're substantial, as I recall. I think one was 30 million and
Yeah, if I give a
huge.
little bit of background on
Please.
each of these. So Germany in July 2012 introduced a sports betting tax. We were operating at that time what we call the Betfair exchange, which is obviously a peer-to-peer act as opposed to us taking the risk of the bookmaker, which you will understand. It was clear that it was not clear as to what the regulations were and how that
Clear as
tax
mud.
regulation, exactly how that would apply to a peer-to-peer product as opposed to a straight betting product. We switched that off pretty quickly in November 2012. The German tax authorities raised an assessment for 30 million euros. So, well, these days, just under $30 million, which was over 10 times the revenue that we actually generated as Betfair. And there are certain things within the German constitution about tax not actually basically shutting businesses down and causing them to cease operations. So we felt there was a legal basis on which we should go forward. We appealed the tax assessment. We have paid that when we lost in both the local fiscal German tax court and the federal German tax court. And we've recently filed a complaint to the German Constitutional Court because in our view, this is an unreasonable fine to be put onto business, which is over 10 times the revenue we even generated during that period.
Yeah, I don't understand how you can levy a tax that exceeds the revenue by 10 times. It did not. I'm an English major, but the math didn't quite make sense to me.
Commissioner, I would be on the same page as you on this one. I find it quite difficult to understand that. And then we'll come on to Greece, which is not dissimilar.
And before you move on to Greece, has the briefing been completed for I think it's the final Supreme Court or another court, the highest court in Germany? Where are you procedurally with that?
Sorry, procedurally, we are complete with our submissions, and our submissions have been made.
Will there be oral arguments?
There won't be oral arguments. It'll be read on the basis of briefs.
Okay, thank you.
Yeah.
I'm sorry, while you're up there, may just ask another quick question. What was the justification that the lower courts that denied your earlier appeals gave for allowing a tax that's 10 times more than your revenue?
I have to be judicious in how I answer this question, but it's as Jonathan, I think, alluded to. It's effectively an interpretation by their courts to the benefit of the jurisdiction.
Yeah, it seems difficult. I mean, both of them were so substantially.
And I refer back to Jonathan's comment, which is we can appreciate that perspective. Yeah.
Okay, thank you.
Yeah, I'm not overly happy about it, but we are where we are. And we will settle that and move on, and we'll see how we get on in the Constitutional Court. In terms of Greece, we had Paddy Power operated a sports book there and gaming business under an interim license until 2020, paying all the Greek taxes. The Greek authorities undertook an audit in relation to 2012, 13, and 14, and the Greek authorities raised an assessment for underpaid taxes of 15 million euros. So again, $15 million. That included penalty and interest. That was more than 5 times the Paddy Power revenue generated during that period.
I'm seeing a disturbing pattern about a grave math error.
With Greece, yes, it's not an unexpected disturbing pattern, but it is a disturbing pattern all the same. We obviously appealed that tax assessment as being not reasonable in our view, I think is the right way to put it. We've paid the tax and the penalties and the interest. Ours was significantly smaller by a factor of 13, 12 times than somebody else. There are a series of appeals going through the courts for ourselves and various others. We have an appeal with the Greek Supreme Administrative Court at this time.
And is briefing completed there? Are you waiting for oral argument?
Absolutely. Sorry, briefing is complete.
Okay.
Due to the COVID pandemic in the situation, there's been multiple delays in the Greek process.
Understood.
We fully disclosed exactly what Jonathan has outlined, so it's there to see in our annual report. But we expect I think towards the end of this year, early next year, hearing in
Ruling,
that
okay,
regard.
or hearing, okay.
Yeah.
And how has it changed the way you conduct business in those two jurisdictions?
Made me somewhat more risk averse. Thank you, Commission.
Thank you.
Are there any other questions before we bring up individuals? I'll simply say that any of the questions that I had have been answered by the numerous questions of my colleagues. So at this time, if you wish to bring up.
Certainly, we'd be happy to. If I could, for starting with the individuals, we'll start with the chair of the Flutter board, which is Gary McGann. Mr. McGann.
Morning, Chair. Good morning, Commissioners. Thank you very much for the opportunity to speak to you this morning. For clarity, I suspect you probably know it. Peter runs the company and I run the board as a public company. My own background is way back when I was a poor accountant, but I spent most of my life running businesses in the telecoms, the drinks industry, the aviation industry, and then the paper case packaging business. I joined the Flutter board, which at that time was Paddy Power, so a legacy company of Flutter, in 2014, and became chair in 2015. And then we had the various mergers of Paddy Power and Betfair and Stars Group, and we acquired Fastball's interest in Fanduel, and here we are today. So the board's role in life is to agree and undertake with the executives an appropriate strategy that looks after the best interests of shareholders and all stakeholders, and that you've heard from both Peter and from Amy that the wider stakeholder group is critically important to us as well as the shareholders, and most shareholders nowadays get that. We appoint the senior executives and hold them to account, and we also take a view as to the culture that underpins the business in terms of achieving the outcomes that we want. And we do this, and then finally we take view on risk in its widest sense, and risk appetite, risk mitigation, etc. And we do most of this work through committees. So we have an audit committee chaired by Holly Keppel, who's a US woman who's also got experience in the UK. We have a remuneration committee, which is chaired by Andy Higginson, who is an Englishman. We have a risk and sustainability committee, which is chaired by Dave Lazzarato, who is a Canadian. We have a workforce engagement committee, which is a new development in the UK about boards having regard and a better understanding of the dynamic in the wider organization as to what's what. It's not a lobby group, and it's not a trade union by other names, but it is something fundamental to underpin the culture of the business. And we have an OMCO. And if I could spend just 2 minutes on the Risk and Sustainability Committee, which we established way back in 2018, I guess. And its role effectively is, by modern standards, the ESG subject, so environment, sustainability, and governance. But and it does all three. But in our world, it mainlines on responsible gambling and gaming, safer gambling and gaming, and obviously the whole issues around climate and governance. And in doing so, spend quite a degree of time in agreeing with the team what we're trying to achieve. And I spend a lot of time talking to the chair of the Gambling Commission in the UK with my co-chairs of other companies to work with them to develop a best in class approach that actually has regard to the practicalities of the business as distinct from the theoretical views of the business from the regulatory point of view. And we're building quite a relationship. And I would say, and I can say that with some degree of authority, that they have a very high regard to us, mainly because Peter has led the executives of the industry in trying to raise this bar. And arguably, why wouldn't they? I mean, we're in the business of sustainable success, not short-term success. And to do that, it needs to be a good, wholesome entertainment business that doesn't damage people. And so there's a lot of work going on there, but we have some of our top non-executive directors on this risk committee, and we work around best practice, developing markers of harm and understanding and intervening into problem areas before they're. So that in essence is what the board does, and that's what I do. So thank you for your time and for the hearing. Happy to take any questions.
Thank you. Do we have any questions?
I have just a quick question, if I may. Thank you
Sure.
for being here, sir. And your background gives me no pause for concern. You have an exemplary background, and seems like the company's very lucky to have you. With respect to the AML reporting, I noticed in the materials that any policy changes on the AML policy have to go through the board. Is that this risk committee that would handle review of that?
On which I sit actually, but yes, the chair of the risk committee consults with we have very strong, as Amy has defined it in the US, but we have that across the group. So we have a very strong regulatory and compliance team in every one of our 4 divisions that Peter has talked about, and a central group one, and it has to come through that process. It's not to reduce the standards ever, quite frankly. It's always to increase the standards and tighten but to try to do so in a way that we can continue to do business and not find ourselves in total logjam.
Of course. Okay. Thank you so much. I don't have any further questions.
Thank you.
Sir, it seems
Sorry,
like
beg your pardon,
there's a
beg your
huge commitment and investment internally to make sure that you stay ahead of these issues. You don't seem to fall behind. This is something that you focus on heavily, and I think that's excellent that you are on the board. I think you're perfectly suited for it. If you could just speak briefly, Mr. McGann, about your work related with Ireland funds. I think you've been involved since 2018. That's a philanthropic foundation, or the Bernardo's Ireland group since 2015. Pick your choice. I just wanted to hear more about the work you do for either the underprivileged children or the philanthropic foundation. I'm interested in that.
So I have 3 daughters and 3 granddaughters, so I'm under serious pressure to do something worthwhile other than what I've been doing to keep them in the manner to which they're accustomed. And one of my daughters is very big in the children's area. She's a Montessori teacher. She has just had a baby all on her own. So she's a kind of a pioneer in this area. And she encouraged me to join Bernardo's, which looks after the children that have been left behind in a very well-off country, such as Ireland. So these are the children of drug addict parents who've had a terrible background. And we don't take them from the parents. By quite the contrary, we work with the families and try to equip the parents with our support to feed them, to clothe them, to train them. We've had some tragic circumstances during COVID because obviously these were left behind and domestic violence became a bigger problem. And we have a fantastic team of social workers, social scientists, all highly qualified, being paid very, very modest salaries to do the most incredible work. The board is a voluntary board, so it gives the same type of commitment as all boards do, but they don't get paid for it, obviously. And it's from very diverse backgrounds. And I'm there as somebody who's been in business and tries to keep the charities in Ireland have a mixed record of problems. And so people from business help them keep it on the straight and narrow on the business side, so as not to intrude on the real work, which is children. Ireland Fund is a very simple one. Dan Rooney is the Pittsburgh Steelers, and Tony O'Reilly, who was the Heinz Corporation CEO, decided to help out Ireland in terms of the North-South problem 50 years ago this year. And we basically put money into community groups to try to break the divide between Protestant and Catholic haves and have-nots and avoid violence and trouble in Northern Ireland again. The Brexit and the protocol isn't helping, but we're getting there.
Well, sir, I really have to commend you. Sometimes I ask people about their charitable work. They maybe have 2 or 3 words to say, but it seems like you're truly involved and you really care. So I thank you for that, and I'm sure your family is very proud of you.
Not sure about that. Thank you.
Thank you for your hard work.
Thank you very much.
Giving back.
Thank you.
Thank you. And next, I'll ask Peter Jackson to come back up.
It's not often I can get to speak after Gary, but one other thing I just add is it's his birthday today. So,
Happy
you know,
birthday. We turned up the heat for you here in Vegas. Happy birthday.
Look, as Gary says, he chairs the board and I run the business, and I think I took you through the company presentation earlier. In terms of a few brief words about my background, I joined the board of Flutter as a non-executive director in early 2013 and joined the company as chief executive at the beginning of 2018. Prior to that, I have had a lot of experience in regulated industries, primarily in the financial services sector, where I ran a business called TravelX, which is in the foreign exchange and payments industry, and prior to that, ran the consumer bank or consumer business of a bank, Lloyds, in the UK.
Thank you. I am not sure who's going to have any additional questions since we've kind of picked your brain a lot today. So I don't think any of us have any concerns about your background, and therefore we just appreciate you being here today. Thank you. And I know you have several others who are going to address us.
We do, and I'll ask Jonathan Hill to come back this time for a moment.
Okay, thank you. Mr. Hill?
So I am the Chief Financial Officer. By background, I'm an economics graduate, and then I'm a qualified accountant for my sins, some might say. I've also worked in a range of industries, quite a lot of them with regulatory overlays. So this is not my first regulated industry. It's my third role as CFO of a publicly listed company. I was firstly the CFO of a house building company. I've also been the CFO of an insurance and travel company, which owned cruise ships, which is a strange mixture, but that was also FCA regulated at that time. So I've worked in a very heavily regulated business there. And then I came to Flutter and joined in 2018. I've been working with Peter, and that time we've underseen a lot of change. We moved the business to a primarily regulated or regulating business with around over 95% of our revenues coming from regulated or regulating industries. My role is reporting the results of the business, financial control, and forecasting of the group. But I think I also look after tax. I'm involved in M&A when that takes place, and obviously investor relations is a big part of my role, both in the equity and the debt markets. But primarily, Peter and I undertake a role of capital allocation, be it organic or inorganic investment, and that's how we run the business. And business to run their own autonomous divisions because they understand much more about their customers than we possibly could.
All right, do we have any questions? No, thank you very much. Also appreciate your presentation today and your answering our questions.
Next, I'd like to introduce you to Paul Cutter, who's the Chief Information Officer.
Mr. Cutter, welcome.
Good morning, Chair and Commissioners. My name is Paul Cutter. I'm the Group Chief Information Officer. I joined the company in 2014 as the Chief Technology Officer of Betfair. And then when Betfair merged with Paddy Power in 2016, I became the Chief Technology Officer of Paddy Power Betfair, and then became the Group Chief Information Officer of Flutter in 2018. I have a 25-year career in the IT industry, following my education in mechanical engineering. So I switched from mechanical engineering to software engineering at an early age, it seems like now. Thank you for your time.
Thank you. Do I have any questions? We have no questions. Thank you very much for being here today. Thank you.
Next, I would like to ask Ed Trainor, the Group General Counsel and Corporate Secretary, to come back.
Hello again, and thank you again for your time. I'm Ed Trainor. I am the Group General Counsel and the Company Secretary of Flutter Entertainment PLC. By background, I'm an Irish qualified lawyer, having trained in Ireland after studying in Ireland and in the US, in Chicago, DePaul University in Chicago, Illinois. I spent a period in private practice, followed by a period in telecoms, again, heavily regulated industry. After that, in 2015, I joined Paddy Power PLC, as it was then, at the same time that Gary McGann was appointed as chair, as the company secretary, and have been company secretary since. My role in the company is to oversee governance, compliance, particularly around our listing rules and the requirements of being a dual listed company, both in the London Stock Exchange and Euronext in Dublin, and also oversee governance across the entire group. And that's what brings me here today. So I often sit as a director of the material subsidiaries and the subsidiaries that are applying for the license here in Nevada. Happy to take any questions that you might have.
Do you have any questions? Yes. Commissioner
I did my undergrad work at DePaul. What year were you there?
I was there in 98, 99.
All right. We would have overlapped.
Very good.
Yes.
You were probably
downtown though, right?
I was in the Loop campus. Yeah.
Lincoln Park.
Yeah. I lived at Lincoln Park.
Any other questions or comments?
I was just curious. You went to DePaul for 1 year, and then did you transfer to the University College in Dublin?
No, University College Dublin is my undergrad. That was so in Ireland, our system is that law is an undergraduate degree. And as part of that, I spent a year of my studies in DePaul in Chicago.
So was that undergraduate
Yes.
work?
Yeah, undergraduate for us, but it's obviously postdoctorate JD and
No, I understand. Yeah, thank you. I misread it. I thought
Oh, no,
you
no,
were in
absolutely.
Nepal for law school also.
Yeah.
So I just wondered how that worked. No, your background is unblemished, so I didn't have any questions with regards to that.
Thank you very much.
Thank you.
Thank you.
Okay.
All right, next I would like to ask Amy Howe to come back up.
Morning again. Amy Howe, I had the good fortune of running Fanduel's business in the US. I joined the company February of 21 as president and was formally appointed CEO in October of last year. Prior to Fanduel, I ran the North American division of Ticketmaster for Live Nation Entertainment, where I was with that company for about 7 years. Before Live Nation, I was a partner at McKinsey & Company, spent a better part of 15 years at McKinsey. Received my undergrad degree from Cornell University and an MBA from Wharton. Grew up in Buffalo, New York, and my husband and I are raising 3 boys, which might be my proudest accomplishment.
Thank you.
You have a very impressive background. I just wanted to tell you one. I read through the materials. You kick butt.
Oh, thank you.
Doing what you're doing.
Thank you so much.
It's aspirational. People need to see you in the position you're in so they can aspire to it.
I really appreciate that.
Well, appreciate your hard work.
Any other questions or comments?
I didn't have any questions. Again, I agree. I mean, I think you're a great role model, and I appreciate all the efforts you're doing or taking towards diversity. So girls need more role models, and it's nice to see you out there getting it done. I do appreciate your community involvement too. I would say that, I know the executives are very busy, but you all need to take a few lessons from your board chair. He's done some amazing community work. So, we love to see that because it shows that you're engaged with the communities that you're in. So
Yes.
thank you so much.
Jerry, it's very inspirational. I learned a lot today. Thank you.
Understood. It's hard to balance everything, but as much as your time allows, it's nice to see you involved.
Thank you.
I also echo the comments of my colleagues. I think, obviously your background is impeccable and without question. I would just echo the board and saying brick and mortar in Nevada might be a consideration, or employees, or some presence here someday. Never say never.
I agree. Never say never.
Never say never. And thank you for being here today and answering our questions. Appreciate it. Did you have anything else? Thanks.
All right, and we have just one last but not least, Andy Giancamilli, who's the COO of Fanduel.
Good morning, Chair and Commissioners. My name is Andy Giancamilli. I'm the COO of Fanduel. I joined in 2015. I have the responsibility of overseeing our customer service, fraud, payments, data and analytics, and strategy groups, and report to Amy Howe. Largely, my job is to ensure we execute at the highest level in accordance with the 10 principles that Amy shared with you on a slide. Said another way, I basically keep the trains on time. And that's my role. Prior to Fanduel, I did about 6 years in consulting, also at McKinsey, and also worked in retail. And while I'm not a lawyer, half a mile up the street from DePaul's Lincoln Park campus on Sheffield Avenue. So happy to take any questions.
I didn't have any questions regarding your background, but kind of related to the prior comment. Once, assuming this transaction gets approved, which, I mean, it looks good at this point, at least in my mind, are you planning on having any employees in Nevada?
So it is definitely under consideration, especially as within online gaming, we're seeing a lot more of the Western states. And when you run customer service, it helps to have an employee presence on the west side of the United States. And funny enough, we have actually commissioned the study and started looking at offices. Las Vegas and Nevada is one of those places that we would do it in. And it definitely helps in terms of a talent pool, given the history that the state has in regulating gaming. So it is most certainly a consideration of ours.
So how would the support for the Fremont project be done? I mean, what resources would you call upon, like if there's a customer dispute at 2:00 in the morning?
So that would all be handled through Boyd, through Fremont. Fanduel wouldn't get involved with that at this point. It would be more customer support for some of the other jurisdictions that they might want to support. For example, if California or another state would come online.
Right, but I understood that you wanted any like patron disputes reported to them. Is it just a report and they do nothing until their next business day? I mean, they allow Boyd to handle it because generally those get resolved pretty quickly.
Understood. Yes, my apologies for the confusion. So Fanduel would support Boyd in responding to any patron dispute, but the inbound call would not come from any patrons directly. So they would have customer support available at any time at Fanduel.
Is it from a particular office or I apologize if I cut you off.
It's mostly in New Jersey. We have a presence in Portland, Oregon as well, and in Florida. So depending on the nature of what it is, and in this case, it would be retail. It would most likely go through our New Jersey office. If it's a fantasy question, we'll handle that mostly out of our Orlando office. So we do have different offices across the state.
Thank you.
Thank you.
A question regarding DFS. In our materials, it says that you're not currently pursuing daily fantasy football in Nevada because number one, you haven't applied for that license. Is it your intent to apply for that license? I know it says not in the near term, but is DFS still such a big part of your business that you would see that as a big opportunity in the state of Nevada?
So Commissioner Cohen, I think the intent at this time is not to offer daily fantasy sports in Nevada. My understanding is that if they wanted to offer it, it would have to be in connection with an operator of a sports pool license, which they would not be eligible to get because they don't have a brick and mortar location.
And just
Never
steal a
say
line
never.
from my boss, never say never.
Exactly.
Thank you.
Well, that concludes our affirmative presentation. We are, of course, happy to answer any additional questions, but would request positive approval of the application.
Are there any additional questions?
And is the most current version and iteration draft number 3 of the order of registration dated August 9th?
That's correct.
Has that been reviewed? Any comments, any issues?
It has. We believe it is in proper form.
Thank you.
All right, there being no additional comments or questions, I believe this is the proper time for a motion.
Thank you, Chair. I move for approval of non-restricted item number 2 as recommended by the Gaming Control Board as read into the record by Madam Secretary, with the understanding that draft number 3 of the order of registration dated August 9th, 2022 is in proper and acceptable form.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
And it appears there are none opposed. Thank you.
Thank you
Thank
very
you for
much.
being here today.
Thank you.
Appreciate your
Thank you for
speaking to
traveling
us.
to Las Vegas to be here. We do appreciate that. And happy birthday.
my mother's birthday today.
Aw.
Yeah. Okay, if we could, Madam Secretary, read in non-restricted number 3.
Non-restricted number 3 is the application of Flutter Entertainment PLC for a continuous or delayed public offering. It is also the applications of Betfair Group Limited, the Sporting Exchange Limited, TSE Holdings Limited, and Fanduel Group Inc. to guarantee securities and hypothecate assets in conjunction with a delayed or continuous public offering.
Good morning again, Chair Tagliati, Commissioners. For the record, I am Erica Oakberg. We are now before you for Flutter's first shelf approval. For purposes of the record, I want to note a few points. First, there are no immediate plans to use the shelf. Second, they meet the requirements of Regulation 16.115. They have a class of securities on the London Stock Exchange which exceeds equity in $10 million. They have filed all required reports, and this is pursuant to draft number 2 of the shelf order dated August 2nd, which we believe is in proper form. As we did at the board meeting, I would request that we incorporate by reference the financial presentation provided in the last item. But of course, Mr. Hill and I are here to answer any additional questions.
Okay, does anybody have any questions? I think there were a lot of.
And it's just an application for a 3-year continuous or delayed public offering.
That's right.
I have no issues, no reservations. Thank you.
Thank you.
Anybody else? All right, does anyone have a motion?
Thank you, Chair. I would move for approval of non-restricted agenda item number 3 is read into the record by Madam Secretary and recommended for approval by the Gaming Control Board and give the authority to the chair to execute draft number 2 dated August 2nd.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
And it appears there are none opposed. Thank you.
Thank you very much.
Thank you. Excellent presentations today.
Thanks.
Good luck.
Madam Secretary, please read in non-restricted number 4.
Non-restricted number 4 is the application of David Russell Zorns for finding of suitability as a key executive.
Good morning, Madam Secretary, Chair Tagliati, Commissioners Solis Rainey, Cohen, Brown, and Keycoffer. I'm Greg Gimignani from the law firm of Dickinson Wright, representing Nevada Casino Holdings with regard to the application for finding of suitability for Mr. David Zorns. I also have David Zorns along with me today, along with Mac Potter, who's the Chief Operating Officer of Nevada Casino Holdings, Larry Hill, who is CEO of an affiliated casino in Colorado, and Tom Reinhardt, who is one of the owners of Casino Holdings. As you'll know from your materials and from the Gaming Control Board hearing transcript, Mr. Zorn's application process was complicated by a complaint lodged by a former employer more than a year after his employment ended with that employer. Mr. Zorn's worked with the Investigations Division and prior to that with the Enforcement Division regarding the issues raised. At all times, I think Mr. Zorns has been honest, cordial, respectful, and responsive. We're not actually privy to the complaint itself, but we did work with the board agents going through the issues raised, or that we were informed of by the board agents. In the end, I think you'll note from the board meeting that while there were some post-employment disagreements regarding Mr. Zorn's apparent authority while working at the Red Lion and his former employer's view of that authority, there were no findings of criminal wrongdoing, and it was apparently, as was apparently alleged by his former employer. Mr. Zorns does have an excellent relationship with his current employer, and at the board meeting, there was a request that he enter into an employment agreement with his current employer that provides clear lines of authority with regard to his role and with regard to comps in particular. That employment agreement has been submitted to the Gaming Control Board, to the Gaming Control Board agent, submitted yesterday. I think it's pretty clear with regard to the comp policy that he's going to have to adhere to at his current employer, although there have been no issues in the last, since 2017. I guess it's 5 years with regard to that with his current employer. Through the process, I've come to admire Mr. Zorn's ability to deal with adversity, including operating in a really competitive but small environment in Elko, remaining highly productive despite multiple health issues, including beating cancer and a more recent stroke. I've also come to respect his long career and his willingness to meet new challenges and adapt. He's been a part of the gaming industry for over 40 years, which you'll see from the materials. He started his career back in the 1980s. He moved to the Elko region to run the Red Lion in the early 80s, was hired by IGT in the late 80s to open a casino in the Caribbean. He moved out for that when IGT decided that they didn't want to be an operator anymore in the Caribbean. He came back to Nevada to work in the Silver Club in Sparks, was rehired by the Red Lion again, left the Red Lion in 1992 to open 4 different casinos, some with common ownership in Colorado, returned in 2005, where he was again hired by the Red Lion, was separated from the Red Lion in 2017, sat out 3 months pursuant to his separation agreement with the Red Lion, and was hired promptly by Nevada Casino Holdings. And with that, I'd like to invite David Zorns to come up to the podium with me and address any of the issues that you may have, or if you'd like, we can go through some of those, the issues that were raised.
Mr. Gimignani, before we move on, I just had a quick question. We received a copy of the Executive Management Employment Agreement. The copy we have isn't executed. It was just submitted?
Yet. It was
Okay.
submitted for review by the Gaming Control Board, just to make sure that we have addressed all the issues that they would like
Got
to
it.
address before we
So-
execute.
Perfect. Thank you so much.
Thank you.
So the intention is, if it's acceptable to the board, to execute it?
Absolutely.
Okay. So I guess I would ask I really don't want to direct you to make a presentation. It's up to you. I'm sure there'll be potential questions here, so it's up to you. You
And I'd like
decide.
Mr. Zords to address at least the issues that were raised in the investigation, as he did at the board meeting.
Thank you.
Thank you very much, Madam Chairman, Commissioners, Madam Secretary. I came back to the Red Lion in 2005. I started an airplane program when I was at the Red Lion previously in the 80s. And part of my coming back to Elko was to actually quit the airplane program that I'd put together because times had changed. When I first did the airplane program, there was only gaming in 3 states, United States. This was a 121 certified airline, and I was vice president of the airline also. So the idea when I came back to the Red Lion was to try to get the property operating without the airline, to become a locals casino. Having had the experience in Colorado for almost 15 years, which was a locals market, I felt that I could take the property and get it operating for a locals market. Elko is a very small town. I was the CEO over 4 properties, but I was also the general manager of the Red Lion. I was casino host, marketing director, kind of a hands-on person, and I had a good relationship with the community. A lot of the misunderstanding and with my former employer was on comps. I did things where I gave $50 gift certificates to several different customers, most of the time that I had a relationship. I did have, though, an unlimited personal comp policy and an unlimited business comp policy. So I wasn't going against the policy of the company, and these were not large amounts. The amounts were $50 and a total of 2 $50 certificates. So in the 15 years that I was there, I felt that we built up the business very well with the locals. I had a very good reputation in the local community, served on the Boys and Girls Club, the Elko Development Authority, and currently still chair of the Casino Convention and Visitors Authority. And with that, I'd like to just answer any questions you have, what's come up.
Okay, I'll start with Commissioner Brown. Do you have any questions?
I do.
I'm sure.
How did you know? Well, I really, I went through the materials extensively.
Yes.
And I will tell you, I was troubled by a number of the things that I read and that I saw. And I was equally troubled by your rationale and some of the justifications you provided for what you did. So you admitted to what you did. And I do understand from the review of my materials, you did not violate an express policy. When you say unlimited comps, business comps or for guests, it was unlimited. But just because something's not, doesn't have a limit, doesn't mean you should use your power. And so I have a series of questions for you so I can better understand whether or not you have satisfied what I think is your burden.
Yes, ma'am.
For suitability.
Yes.
And I just appreciate if you're honest and just answer the questions directly.
I will do that.
Thank you. So when you lived in the company housing for 10 years, did any of the company employees come to fix things for you, shovel your driveway, provide IT services, any gardening services at the company condo?
Yes, they did.
Okay, and did you pay them?
No, I didn't. A lot of times if they would do things extra for me, I did pay them, yes.
Okay, and did they come and do things for you during company time or on their free time?
In the company condo would have been during their company time.
Okay, and that was acceptable?
Yes.
Okay, and one of the justifications I remember you provided either in your written materials when you provided letters or during your presentations was that you're entitled to take these comps and that you were never disciplined or written up for taking any of these comps. Do you recall that?
Yes, I do.
The concern that I had is when I saw statements from the Wolves, it didn't seem like they were aware of what was going on. So I don't doubt that you had a collegial relationship with them and they trusted you, but it seems like after your departure, and it wasn't for any of these issues, as I recall.
Right.
It was after your departure when they reviewed carefully the day-to-day operations and the books and records that they were actually very upset. Were you aware of that?
Yes, I was.
Okay. And why do you think they were upset?
This was over a year after I left. I couldn't tell you exactly why. The only thing I will say is that there was a monthly comp report that was prepared with the financial statements that was prepared every month. And I do know that on several occasions that comp report was given to them. And I don't want it to seem like was large amounts of comps. I mean, we're talking very low $200-300 type ranges at most.
So it's
And-
my understanding, sir, between 2015 and 2018, that the records reflect that you issued 1,251 gift certificates by you that were redeemed by patrons for a total of $62,085. Does that not seem large to you, sir?
Can I explain that, please?
Please, this is your opportunity. I hope you view this as an opportunity.
Please. When I first came back to the Red Lion, the sponsorships and donations were pretty high. They were almost all cash donations. I changed the system to where the only thing that we would give away was gift certificates for meals in one of the restaurants. So the program was completely changed from giving any cash to giving away any gift certificates. It was also changed to where they had to fill out a form requesting what the donation was for. And this is a lot of times were things like golf tournaments to raise money, that type of thing. So the gift certificate log you're talking about was every one of those gift certificates was made out for donations. It was turned in on a log with the gift certificate number, who it went to, the reason that was turned into accounting every month. Also on that same gift certificate log was gift certificates were made out, signed by me, given to the gift shop on a log where they were sold, because we didn't have a card system, you know, like you do credit cards now for gift cards. So that was part of the whole gift certificates.
And does that number seem substantial to you at all?
Yes, it is.
Okay.
Yeah, but again, those were not my personal, they were not personal things that I gave away. These were donations, sponsorships.
Did you ever receive any personal benefit tangentially in connection with these gift certificates that were issued and redeemed by patrons?
Yes, I did.
And could you give me some examples?
An example is I had a patron that had a condo in Mesquite. He let me use his condo, and I gave him two $50 gift certificates. He was also a very good customer. I did feel that it was 50-50. It was for my benefit. He was also a good customer of the company. And may I also please say that I do not look at things the same way I did at the time. And after I look at this after the fact now, I can see why it was brought up. I would not do things the same way. I think that it left myself open for people to look at it in a different way. I can certainly understand that now.
Well, it wasn't a one-time incident. It was, I believe, a reflection of your character to do these things over and over, year after year. And that's what causes me consternation, because you just now, by way of example, gave your justification. I got a benefit, but so did the Red Lion. So there's this constant rationale of yes, but. So I'm not sure, even today as you stand here, for me personally,
yes,
that you appreciate the ethical implications of what occurred.
I feel that I do. There was I gave you the one instance that was definitely because I wanted to show you that I did know that there was things for my benefit. There was another thing that got brought up, that there was a gift certificate giving for a massage. There was a lady that gave massages on the property, and that was given to a Roxy that was in your report. Her husband was a VIP player.
Of course, he could go gamble so she can go to the massage.
Yes.
I understand that. I don't see that as an issue. That's not a problem for me.
That
I
was
think is
the
a good
majority,
practice.
and I'm not trying to argue with you, because
No, I don't
definitely-
see this as an argument
I
at all.
definitely do say
No.
that there was times that I did do it for my benefit.
Yes.
But for the most part, they were done business relationships.
No, I understand. And I know that sometimes in your mind, you kill two birds with one stone. And if you get a tangential benefit, so be it. But I do believe your rationalization is that the Red Lion also received a benefit.
I felt that way most of the time, but I would not do it the same way today.
Only because it's become an issue.
Because I realize it's an issue, yes.
Yes. Are you surprised to hear that the Wolves characterized your conduct as unethical activity?
I was at the time. I think that probably hurt me more than anything else, because I had such great respect for Larry Wolf Sr., Larry J. Wolf. I respected the man. He could have told me anything and I would have done it. I wish that these things would have got talked about, because I would have done anything that man asked of me.
Well, I noted in the materials that you said I was never disciplined. Nobody ever wrote me up. Nobody ever talked to me about it. Is it possible that they weren't aware of the extent of what you did? And then after the fact, when they did appreciate it and realize it, they viewed it as unethical activity. Do you view what you did as unethical in any way?
Because I did have the authority for comps, and because those comps weren't high in any one month, I at the time did not feel that it was unjustified. I knew that they've got a comp report every single month. It was on the financial statements. As those gift certificates that we talked about were also on the financial statements every month as far as sponsorships. So I was a little surprised that they took it the way they did.
I believe in your mind, you're conflating the issue of I have unlimited comps with using those comps for your self-interest and to benefit yourself. I still don't think you are understanding that dichotomy. And that's what's troubling to me. Not that you did it,
Yeah.
and that you acknowledge maybe today, if I did things differently, knowing what I know now, I would have done things differently. But I still hear you making these justifications, which gives me pause about whether or not you understand that it might be viewed as unethical activity.
Yes. I mean, since then I've had, trust me, a lot of unrestful nights where I didn't sleep about this and thought about it and wished that I would have not have done it, because I know it could be viewed as unethical, and I just wish I would not have done it that way.
What do you have to say about Vicky Zorn's comments about your lack of integrity and that you're a deceptive person? And I know for the record, you've been married 5 times.
It's my ex-wife, and it was not a very good divorce.
Okay. And are you familiar with a gentleman by the name of Ruben Garcia?
Yes, I am.
And did you authorize the Red Lion to make his car payments of $500 a month to cover up his DUI and inability to operate a motor vehicle owned by the Red Lion?
This is the first time this has come to my attention. I'm trying to remember the circumstance of, excuse my pause in that.
No, take your time. I'd like you to.
It's been quite a while ago. I know that he did have a DUI, and he was not allowed to drive company vehicles. So I wouldn't be surprised. I don't remember specifically, but that sounds like it was very possible that he was giving a car allowance for driving his own personal vehicle.
And did you authorize the payment of the car allowance to circumvent any issues relating to his DUI to make sure he could drive to and from work?
I really don't know how to answer. I guess I don't remember it. I don't remember it well enough. I didn't take it as circumventing something, I guess.
Did
I knew
you
that-
authorize the company to make car payments directly for him because he had a DUI?
Don't believe we would have made the car payments for him. He might have got a $500 car allowance, is the way that I would remember it, to the best of my knowledge.
And did any other employees have car allowances?
I don't believe so.
Okay, and do you know why it was done for Ruben Garcia?
He was the chief engineer for 4 properties that had to drive around between the 4 properties a lot, had to go to Home Depot, or, his job pretty much required him driving.
And did the car allowance coincide in any way with a timeline with the DUI?
I don't believe so, but I cannot remember exactly, ma'am.
Okay, and did Saul Marin deliver a hot tub to your house during company hours?
He was probably part of the crew that took the hot tub to my house, yes.
During company hours?
Yes, I found, yes, it was during company hours.
And did Ruben Garcia do tile work at your house during company hours?
No, the tile work he did at my house was not during company hours.
Never, not once.
Although, since he was a salaried employee, any time I guess could be said that it was during.
Okay, and did Saul Garcia do a chemical wash on your interior walls at your house during company hours?
No, he did not.
Okay, did Rudy Romero help frame new walls and complete some drywall work in your house during company hours?
No, he did not.
Did he do that work?
He did some work in my house on his own that he was paid for.
Okay, and you paid for that?
Yes, I did.
So these are all employees of the Red Lion doing work for you at your house, sometimes during company hours, sometimes after company hours.
The only thing that I believe was during company hours is when I moved out of my condo. I moved out of the company condo and bought my own house. Is it that there was some members that moved that hot tub?
Okay, and did John complete some electrical work for your house during company hours?
No,
And did Shane help paint your house during company hours?
no.
But did John and Shane do the work that we just discussed?
I paid electrician by the name of John to do work on his own time. Yes.
These are employees of the Red Lion at the time?
John was, yes.
Okay, and Shane, the
I
painter?
don't think Shane was an employee of the Red Lion.
Okay, and did you ask Lynn Anderson, the in-house graphics employee at Red Lion, to make you a golf mural in exchange for $20 in cash and $40 in free play to be issued by the Players Club manager per your instructions?
It's possible the golf poster would have been for a Red Lion golf event.
It's not for you personally in any way?
No, that would have been
Okay.
for the Red Lion.
Did you instruct Ruben Garcia to delete all of his emails and delete 35 years worth of data from his computer when he left Red Lion in January of 2018?
No,
Okay, were you aware that he did that?
no, not until now.
And did you use your personal credit card when you worked at the Red Lion to get reimbursement for company purchases so you could get points?
I used my personal credit card for my business expenses. Occasionally would buy items for the Red Lion as long as there was not a discount that was available for cash. And I did get reimbursed and I did get points.
Okay, and why didn't you just use your Red Lion company credit card, the American Express card, once you had it?
Once the Red Lion, 10 years into my employment, I requested the Red Lion if they could get their own credit card. And from that point on, I only used that credit card and did not get points.
And you stopped using your personal credit card at that point completely?
Yes, at that time. When the Red Lion got their own credit card, I quit using mine.
And when was that?
Within the last 2 or 3 years of my employment.
Okay, and did you make efforts to cash in your company points, even though they belong to the company on the American Express card?
No, I asked at one time, I asked our controller if she would ask the owners whether I could still get the points. They said no. I never asked anymore. And then it was also policy that I believe we gave it the material that American Express does not transfer points to other accounts.
Did Ms. Holland ever cover for you in any way, shape, or form?
Not that I know of.
Was she not submitting the comp reports to the Wolves for monthly review at all times to cover for you?
To cover for me, I don't know.
So that your comp history wasn't viewed by the Wolves?
All I can tell you is that as a controller, she prepared a comp report every month and it should have been available for review every month.
Would it surprise you if the Wolves were not receiving the comp reports every month, even though they requested them?
Not that, no, that would surprise me if they requested them, they did not receive them. The reason I hesitated at all is that there was a lot of months during my employment that the financial statements were not prepared in a timely manner.
Okay, and did you receive personal benefit from operating the golf simulator while using company property?
I did not receive personal benefit. I know why that came up.
You never used it for yourself?
Yeah, yes, I used it for myself after hours, yes.
Okay,
And
so you did use it for your personal
Okay.
benefit.
there was a sign posted, just to make it clear. The reason I think this all came up in the first place because everybody knew that I had a golf simulator that was located in the Chevron station. The owners had been there. We talked about it in our calls, so they were all aware that I did have this. There was a sign that was put up that said it would cost $20 if you were a non-member to use the golf simulator. And the reason is I had a group of around 10, 12 people that we put in $300 each to be able to use it. And we felt that anybody that was not part of that group that put in money would pay $20 to cover the cost of the parts, like there's a hitting mat that could wear out. And I believe that Larry D. Wolf felt that I was personally making money off this.
Did you ever collect the $20 charge from a single person?
Yes,
And what did you do with that money?
it went into, I bought quite a few spare parts for the machine.
But you understand the use of the golf simulator on company property and company equipment, that was for your own benefit, yes or
Yes.
no? Okay. And did the Red Lion benefit in any way?
Indirectly.
How?
We let the golf team, the local golf team, use the golf simulator. It was just a good business relationship between the kids and the golf team, their parents, and the Red Lion.
And did you use warehouse equipment by the engineering employee Sal Marine to build kitchen cabinets on company time for your home?
I did not. I paid Saul Marine to build my kitchen cabinets. I paid him completely to build the cabinets on his own time.
Did he ever use company time to build your cabinet, sir, that you're aware of?
I was not aware that he ever used company time. I believe in the investigation, there was pictures that were given to me where he installed a cabinet and a timestamp showed that it could have been during company time.
Did you direct him not to use his company time to build your personal cabinets?
Yes.
Okay, but you don't have a text message or an email that proves that, correct?
No, I do not.
Okay. And was it your intention when you purchased the exercise equipment using the company American Express credit card to have it delivered to your own home and not the company?
Yes, it was.
And why is that?
We had a policy where employees, myself and other employees, could buy things through the company. We had to fill out a form ahead of time that showed that it would be paid back. A huge discount by ordering it through the company. So I did have it ordered through the company, and my intention was to pay for it completely when it was delivered.
Okay. And the director of finance, Ms. Holland, I understand her wedding reception was comped, at least in part. Did you contribute any of your comps to help pay for Ms. Holland's wedding reception catering?
I did not even know about this until after I had left the Red Lion. It came up in this investigation.
Okay, it was my understanding that you contributed some of your comps to pay for that.
I didn't knowingly know.
Okay, so you're saying Ms. Holland might have attributed comps to you that you didn't authorize? Okay. And here's an odd one that struck me as odd because I think an employee reported you for taking produce. And you know, you're a leader, you're the boss. So when people are watching you do something like that, I think it really impedes your leadership and it impacts the culture of the company. So can you?
And I agree with that completely. So let me explain what I used to do. Every month I would have one of the waitresses in the restaurant ring up a ticket for between $200–300. She would ring it up, I would sign it, I would give her a tip on the full amount. And it was made aware to all the employees that I did this every month. So if I went into the restaurant and ever went to the buffet line, had a cup of soup, tried something off the buffet line, what you're talking about with produce, taking an apple out of the walk-in when I was on an apple diet, all the employees in the kitchen were made aware that that was at least rang up and accounted for.
Okay. Did you ever use company assets to buy expensive food so you could take it home to have a party or have like a football banquet or something?
No,
Your personal
anytime
use?
anything that would be of any, I didn't take food home, but anything would have been rang up.
Okay. Did you ever have like a golf or fantasy football banquet using your comps at the business?
There was a fantasy football team that stayed or that met once a week at the sports bar. Part of the deal for having them come in once a week, drink and gamble, is at the end of the year, they were giving an appetizer party, which I signed that ticket. We did a Red Lion golf tournament where everybody paid an entry fee into the golf tournament. They had a party after at a banquet, and the meal ticket I signed. What was not shown is that on the entry fee, part of their entry fee went to the cost of that banquet.
And did you personally benefit in any way, shape, or form from any of these banquets?
No.
Did you eat, participate?
I did go to the golf tournament, yes.
Okay, so you personally benefited, sir.
Yes, but I did not. I was not part of fantasy football, and the golf tournament though was an event for the casino. It rented rooms, it brought in gamblers, and it just happened to be that I also hosted it. So yes, I at the banquet.
And you enjoy golf?
I do.
Yeah. So you benefited from that as well personally?
Yes, ma'am.
Thank you. So I'm really, as I view it, I'm having a tough time with this. I have not, of course, spoken with any of my fellow commissioners. I wanted to have the opportunity to ask you some questions to better understand where your mind frame was. And as you know, the top person at the Red Lion, I think as a leader, you should have led by example. As even if no one's watching, because someone's always watching. And even if nobody's watching, that to me goes to integrity and character and who you are as a person in terms of the standard that you have to meet today for suitability. So I don't have any questions at this point. I might have some follow-up questions, but I am troubled by your responses even today in terms of justifications.
I'm sorry.
No, I don't need an apology. I'm just telling you.
I know, but I do feel bad about it because I honestly thought about things. I didn't just do things willy-nilly. Like I say, afterwards, after the fact, I look back at it and I would not do things again the same way. I've worked for this company for almost 5 years now and have not had one of these things that has never come up with this company.
Because you haven't done any of these things. You haven't put yourself ahead of this new company. You haven't, I don't think, asked employees to come to your house to do things on company time. You haven't used comps excessively or, credit card points personally, even though they're used for company business. And so I think your behavior's changed because of the implications of what you've done have been brought to light. But notwithstanding that, I still have issues with your conduct previously as a leader.
I understand.
Thank you so much for being candid.
Before we go to any other commissioner, I just need to see if we're being asked by one of our staff members to take a short break after this item. And so I know there, in light of Commissioner Brown's questioning, if anyone has any lengthy questions they wish to ask, I might take the break now for our court reporter who's asking for it.
Yeah.
We're being asked for a break.
Yeah.
So if you would please be
Thank you.
patient, I appreciate it. Stand by. We're going to reconvene in about 10 minutes.
Okay.
Or less.
Okay.
Thank you.
Hey, Greg, is Mr. Reinhardt
All right, we are back on the record, right? Yes. I can't see behind the screen. Are we good? Thumbs up? Thank you. You have to have long arms for me to see that. Okay, sir, thank you for your patience. At this point, we're reconvening in your matter. And I'm going to go to Commissioner Cohen.
Thank you, Chair. You executed the severance agreement, correct? And that severance agreement had certain restrictive covenants in there. Do you remember those?
It had a 3-month non-compete.
And that 3-month non-compete, did you do anything to violate that 3-month non-compete? In other words,
No.
okay.
No, not so.
And so that's why when you left the employee of Red Lion on 9/17, and then you went to work in 12/17, your restricted period had lapsed as far as you were concerned. Your capacity as chief executive officer at Red Lion, was it similar in duties to what you were doing at Nevada Casino Holdings?
The biggest difference was I was also general manager and wore the other hats, did a lot more with marketing, casino host.
So if anything, your duties increased at your new employment?
Yes, sir.
Would you say that when you went to work for Nevada Casino Holdings, you became a direct competitor of Red Lion?
Yes.
In your capacity as chief executive officer at Nevada Casino Holdings, you went heads up against Red Lion?
Basically did, but because of the size of the casino in Elko, I didn't feel it was very much of a direct competitor. For an example, there is approximately only 300 people on the VIP list for the 2 major casinos in town. Out of those 300 people, between the 2 casinos in Elko, there was only 2 people that were on that list. So it was a different type of clientele.
I'm troubled that I'll go full circle. I'm troubled by what at least we've heard so far is a whole lot of yes, but, yes, but, yes, but. What gives me pause, because, you know, if there were a vote just on your yes, but, yes, but, yes, buts, with nothing to come forward to say, well, wait a minute, there's another side to this story and there's history. There's more than enough, at least in my judgment, you know, for a denial. But likewise, a denial in your particular case puts you out of the business. So, you know, that's why, you know, there's some very difficult balancing things here. What gives me some sort of comfort is what the board proposed on a 2-year limitation. I'm troubled that I don't have an answer, and then I'm going to bring up Mr. Reinhardt if I can. I don't have an answer, is what happened between your termination date, severance date, with Red Lion, and why a couple, you know, what was it, a year? Almost 2 years they came forward, especially in light of there was a non-disparagement agreement, a mutual non-disparagement agreement in your severance agreement. I'm not saying that was breached. I don't know why they did it. Yeah, you've testified today. You're not so sure. Commissioner Brown laid some groundwork, questioning whether or not they even received the comp reports, which gets us back to, when they figured out what was going on. Was it motivated because of the reg that criminal conduct has to be reported? Was it motivated because you were doing too good of a job? I don't know. There's nothing that tells me what that answer is. So if I could, in other words, I'm trying to give you the good side of your story, and there's bad side. There's clearly bad side. But the question is, with the 5 years of intervening work and supposedly a stellar record, is that something that it won't explain away what you did? But have you changed? Have you changed your methods of operation? Have you changed your way of doing business? And hopefully, the contractual agreement that you're going to enter into, assuming this commission goes in your favor, will cover these gray areas. But if you could you bring up Mr. Reinhardt?
And before you do that, in the avoidance of doubt, the Wolves did not bring this forward. They did not lodge a formal complaint. It was the acquiring company who did a review of the books and records and then brought that to enforcement for investigation. And then within, I think, a 5-day period, the Wolves were interviewed.
No, I
So, I mean, in terms of his understanding, that's not what happened.
Wait, 1 second. This hearing's a little bit, as far as people talking over each other. If we could wait for each other to finish, I would appreciate it, just because of the, I'm hearkening back to my district court judge roots. The court reporter can't get all the words spoken by everybody at the same time. Okay.
Mr. Reinhardt.
Yes, sir.
Would you state your name for the record and your position with Nevada Casino Holdings?
I'm Tom Reinhardt. I'm a member of Nevada Casino Holdings LLC.
Do you know who is the person responsible for hiring Mr. Zorns?
Myself and Larry Hill.
Now, there's been an exhaustive record in this case of allegations against Mr. Zorns. And I believe there's testimony that you were informed right away when these allegations were lodged, correct?
Yes, sir.
Who informed you that these allegations were lodged?
I'll give a little bit of a longer answer. I met with Larry Wolf Sr. We had the Red Lion under contract. And when I was terminating that contract, I was here in Las Vegas. I went and had a cup of coffee with him so that I could have this discussion face to face. At that time, also, we had Dave working for us, and Larry Sr. told me that they were going to file a complaint. And so I knew about it prior to it actually being filed. He said that his son was filing a complaint, that he wouldn't do it, but he couldn't get his son to back down from it. So it's interesting that you said that the purchaser filed the complaint when I was told that it was Larry's Jr.
And so I don't mean to say file a complaint. I mean, bring it to the attention of enforcement. That's so I think we might be talking about different things.
Thank you.
Evidently. And then as soon as there was a complaint made, then Dave let us know as soon as he found out about it.
Now, when the complaint was brought to your attention by Larry Wolf Sr., I know there's a difference, an L and a J. I'll just use senior. Mr. Zorns was already working for you.
Sir.
At the time that was brought to your attention, I'm just doing this chronologically. At the time that was brought to your attention, did you have any information in your possession from any source whatsoever that any of the things that you were told that happened allegedly under his watch at Red Lion were happening with you?
Absolutely not. No.
So at least at the time that they were brought to your attention by Mr. Zorns, great employee.
Absolutely. Yeah.
And he remains a great employee.
Yes.
And you've
Yes,
had any issues with his honesty, integrity, forthrightness?
No, sir. Actually, we hired Dave away from, a significant market leader inside of Elko. And so in my mind, I thought, well, he's going to know all these customers that will greatly benefit us. And so, and all of the commercial hotel clients, because the mines bring in a lot of contracts and Dave knows every one of them. And so I thought we're really going to benefit because of Dave's knowledge of their customer base. And he refused. He said, I would not do that to the Wolves. He goes, we're going to fight these things, but I'm not using
I'm not going after their customers. He absolutely refused. And so we were frustrated initially with it, but then we admired it because he has continued to refuse to go after those specific customers he had relationships with. He could have easily picked up the phone and said, I'll beat their room rate.
Have
But
you
he has never done that.
have you heard anything? Let me go back a second. Clearly, you're here today and you've heard all the allegations and questioning
Yeah.
of Commissioner Brown that's in the record. And you were present at previous hearings.
Yes.
Did any of the allegations that were brought forward, either today or at the Gaming Control Board, give you pause that, uh-oh, I may have, maybe there is a problem with this man?
Well, yeah, I mean, if somebody gets the allegations, I sat down with Dave, lengthy conversations about every single one. As we went through and the investigations and our licensing process, we've spent tens and tens of hours together just talking about the ones that really raised what my concerns would be and the optics of things. And I'm satisfied and I have no concern about the man's integrity at all. He's been nothing but a professional in our employer, in our employee. I think that I was listening to the questions and we own hundreds of locations of different businesses across the country. We have about 6,000 employees. And so we have a very stringent accountability system in all of our different companies. And so in these companies spread out across 12 states, people are granted certain authorities and they're held accountable and they're accountable to budgets, accountable to performance, accountable to margins, accountable. But in these like these properties in Winnemucca or Hawthorne or in Elko, these guys do everything and they're on literally his phone. He's on call 24 hours a day, 7 days a week. If something goes wrong, he's going to get the call. He's never gets a break. So when I look at them questioning that he got a cabinet installed on company time, I want my key people to be able to benefit from somebody that can help him. He is my guy on the ground in this community. And so if he could have somebody come and install a cabinet for him, or that he moves out and I pick up the rent on his unit, I think that I just can't, I have a difficult time getting my mind around that they were looking for things. It's like, we are going to dissect every single little thing that we can point our finger at on what he did when he was accountable to him. He was reporting to them every single month. They had calls with his office down here with Rick Stevens every single month. It wasn't that these guys were completely oblivious to what was going on at the property. And if they were, shame on them. But to expect somebody that's going to be running this property in Elko, Nevada, not just one property, all the properties that these guys have, with multiple restaurant operations. Restaurants aren't fun to make sure that they're staffed and operating. All the inventories, all of the marketing, all of the public relations things that your key guy representing you in Elko has to do. And so he passes out, he makes contributions, he makes charitable donations, he passes out whatever to try and generate business and continue the viability of these properties in these small communities, managing the relationships with the bus companies that are taking the miners out and all the contracts and the millions and millions of decisions that he has made over 12 years. And then it's like, well, and here's 12 things that you did wrong. And some of them really do look poorly upon those decisions. And if I'm sure that if I was under that scrutiny of all of these investigators and all of the decisions that I make throughout the day, I would be slaughtered if you held me accountable for the last 12 years. It's when you're the only guy there and you're investigating work comp claims and you're doing all these other things. He was, the host, the manager, he had people reporting to him on the restaurants and on the hotels and the housekeeping and the casino. They're running a gas station. He had a gas station under his purview. He's got a convenience store he's running. It's a million different responsibilities. And so I'm not discounting the things that he is being accused of. I'm not. We've talked about it for hours and hours. We haven't seen anything like that from Dave in his current position.
Let me just end my portion of this. So if we liken this to an employee given a second chance, because clearly during the term of Mr. Zorn's appointment, these allegations came to light. As far as you're concerned, you're comfortable with everything you've seen, everything you've heard, everything Mr. Zorn has told you.
Yes.
Are you comfortable with an additional 2-year limitation on if his suitability to continue in that position?
Absolutely. We're more than willing to, any kind of extra reporting, anything we need to do as an organization. We want Dave to continue in his position, and we appreciate the opportunity if you approve that.
And my final question is, if there were to be a denial, and we understand what a denial, means,
Yes.
you would have to leave the employee.
Yes.
Of you. Would that impact your business at Nevada Casino Landings?
Absolutely. Yeah, I don't know if you received a copy of the letter that I wrote to the control board members, but one of the things that's been difficult after we took these properties over has been obtaining quality leadership at Dave's level that are willing to bounce between Elko and Spring Creek and Winnemucca and Hawthorne, because guys that are, trying to make a career in gaming, that's probably not a great resume builder, right? If you're young, and then I don't really have like one of the reasons that we were looking at buying the Red Lion was so that we had a career path that if you happen to start in Hawthorne and in a department that you could move through our properties and work toward the Red Lion. That was honestly my first consideration when I put it under contract, is to create the biggest property in Elko as a career path to try and attract and recruit people into all of our properties in Northern Nevada. It's a pretty limited opportunity if you're looking for somebody to live in Hawthorne or travel to Hawthorne on a regular basis and oversee that property, make sure that it's staffed and do this, this multi-unit thing that we have to do. And so just getting quality gaming executives in Elko, has been really limited. And we're move people in and then they hate Elko or whatever that, happens. And then you're starting over again. And so Dave has been such a great stability to our company. And he's so well respected in the community that it has been night and day in terms of the stability of our company and our management. It's of having Dave in his position there in Elko.
Thank you, sir.
Thank you.
Okay. Moving down to Commissioner Solis Rainey.
Good afternoon now, I think. Oh, no, it's still morning. Good morning.
Good morning.
Thank you for being here. I had an opportunity to read through all of the materials. I mean, I understand the allegations. They're serious allegations, but I accept your explanations on those. You've made some judgment calls that maybe you wouldn't make today, but generally, I mean, the amounts and the purposes for where you were using these comps to me does not seem unreasonable for somebody operating in a small community like that. In one of the reports, enforcement indicated that I believe it was the controller said that your comp usage was average. Do you remember looking at the comp reports and seeing kind of where you fell in?
I always tried to come in lower than, we had a marketing manager. We had several managers, and I tried to always come in lower than some of the other people.
Okay.
Even though that I had reason that I would kind of have to give some things away.
Right. And it indicated that, I believed it indicated that the your comp usage kind of ebbed and flowed depending on local events and the health of the local industry, so, or the local economy. So it makes sense that, your usage would increase if there was local events where you were getting hit up to donate to the high school or the Elks Lodge or whatever for their different fundraisers.
I didn't finish mentioning, but in those donations that we talked about, we cut the donations in half when we went to give them the gift certificates. And then I also looked at the gift certificates were really only 50% of the face value. So if I gave a $50 gift certificate, our food cost, labor cost, let's say, was $25. So
right, and that's
we
why
really
you use gift
cut it
certificates.
flat.
Yeah, of course. You had indicated earlier that you had some work done, at home by different members of the staff. I get probably the engineering staff, correct?
Yes.
Are there other professionals in the area? I mean, it's a small community. Do those professionals offer services to other people in the community?
There are almost every type of professional in town. To get them to actually come to work for you is very hard, very time. I mean, they've got so much work in that area that you're lucky to get somebody in several months' time. And the costs are pretty high.
To me, it carries a lot of weight that Mr. Reinhardt, is comfortable with what you're doing, at the current property. Had there been a limitation on your comps at your current position, had there been a limitation before the board recommended the one be imposed?
No, there wasn't.
Okay. Is that typical for your other direct reports?
There is a comp limit for each position. So I think a general manager has a limit. For example, I think $5,000 a month, and we put mine at 1,000.
Okay. You mentioned that at the Red Lion, there was different categories of comps. There was personal comps and there was business comps. What was the personal comps?
This was set up before I came to the property. Elko's a hard town to find people to work. The gold mines will hire almost anybody that has any kind of common sense and a decent, clear record. So one of the benefits was giving everybody personal comps. They wanted to take their wife to Starbucks or take them to dinner. They had enough comps every month that they could do that. It probably averaged most managers in the $300. I'd say would probably be about the average area for personal.
So you weren't the only one with personal comps. That was
No.
a benefit that was
Every
offered,
manager.
maybe at different levels to different management staff.
Correct.
And the purpose by their very nature is for personal use. So you
Yes.
personally benefit from
Yes.
them. Okay. I don't have any other questions. I'm satisfied with your responses. I think it's definitely been a learning experience
It has.
and one that you seem to have accepted. So I would be comfortable supporting the applications with the
Also very
limitations.
humbling experience, I assure you. One thing I did want to clear up, if you don't mind, during probably the first, I'm going to say at least 10 to 12 years that I was there, the Wolves themselves didn't get too responsible, too involved in the day-to-day operations. I reported almost always directly to Rick Stevens. And I do know for a fact Mr. Stevens received the reports when they were produced anyway. I didn't know about them not being available at times.
I didn't have anything further pass to my colleague. Thank you.
Thank you. And I think just following up a little bit on Commissioner Solis Rainey. So what was the amount of time that you worked at your new employer after, or I guess before these complaints were originally made?
Pretty close to 2 years.
And so during that initial 2 years, you had no limitation on your comps. There was basically it was you had free reign that you could operate in the same way you had operated at the Red Lion.
Yes.
But you chose not to.
I didn't have a reason to, no.
What was the difference?
Well, for one, we didn't use gift certificates. I think that the current company has a little bit better controls in place in the first place. The comp limit was still unlimited, but I don't take friends and that to dinner. You know, we don't have a dinner type restaurant. I really don't use comps that much.
Okay. I'll probably have some comments. Motions gets made, but
Okay.
that's all I have. Thank you.
So I have a couple observations or comments. You know, one of the benefits of being the chair of this commission is I have an opportunity to observe and listen to the investigators or the agents putting forth their investigation to the board. I don't participate in that meeting, but I observe and I listen, and that's it, because of open meeting laws, of course. And so, and I get to do that for each month. And then one of my colleagues also, they rotate and they participate, and they get to listen to the presentation of the agents of the materials. And at the very first rump that involved was what's this meeting's called, right?
Yes.
Which, by the way, bizarre. And no one can tell me where it comes from, that meeting name, but and it's not the rump. I've been corrected. It's rump. So there you go. Response under maximum pressure. Okay, first time anyone's told me what that is. At rump, before the board meeting, the very first time this was going to be heard and was sent back to staff. And this is something that you wouldn't be privy to, but I just want to bring it to your attention because it was mentioned. I'm not going to ask you to comment on it. I'm not asking you to try to remember the circumstances. I'm not asking you to respond. I just want to bring it to your attention. And that is that at that first rump, when your investigation was presented to the members of the board, there was a reference to agents asking you not to speak to Holland or Garcia, and you did anyway. Now, I don't know exactly the details of that. I don't participate and ask questions in that process. This is the first time I've had an opportunity to ask questions of you. And in the big scheme of things, you know, you've been pretty excoriated and you've had some issues, and I don't think I need to get into the details of it. I'll simply say that at a subsequent rump, there was a reference that the agent thought that you were being honest and that you honestly answered questions and that you gave honest beliefs and honest opinions. And so presumably for them, that trumps asking you to do something and you not doing it. I would just say this. I feel very strongly that when an investigator or an agent from our division tells you to do something, you do it without question. And so just know that whatever the vote is here today, were you to continue on in your capacity because your current employers think that's what they need and want, and clearly that will weigh on the minds of the commissioners here, that that kind of expectation that you will cooperate and you will follow instructions reigns supreme above all things in my mind. And I'm sure there's other people here who would concur. So I would just caution you, again, innocent until proven guilty, right? I'm not asking you to address it, but in the future, going forward, if you deal with anyone from any entity related to the gaming control, that you understand that those are non-negotiable, no free will instructions. Do you understand?
I agree 100%.
Okay, perfect. That's all I really had to say. Thank you very much. Is there anything else from any commissioner before we have a motion that we can discuss? No, okay. So this is the time when we deliberate and vote and you're off the hot seat. Thank you.
Thank you very much.
Okay. Who has the motion?
Chair Tagliati, I would move for approval of non-restricted item number 4 as read into the record by Madam Secretary, subject to a 2-year limitation as recommended by the Gaming Control Board.
Okay, at this time, who would like to make any comment or discussion, starting with Commissioner Keycapper?
Thank you, Madam Chair. The report that we had from 2019 made some very pointed comments that Mr. Zorn was really operating within a gray area. Serious questions about sort of integrity and his understanding of sort of some of the moral aspects of business operations. I see it as sort of a ring of Ganges kind of situation, right? He had the ring when he was at the Red Lion, and he could pretty much do whatever he wanted, and didn't do anything that was shown to be illegal, but maybe questionable, and that ultimately resulted in some serious discomfort from his former employer. It seems that Mr. Reinhardt has taken away the ring, or the board in this commission may take away the ring. And even if he still had it in the past, a couple of years when he was operating or in his first couple of years operating in the new employer, he didn't use it. So I think that coupled with somewhat passionate plea by Mr. Reinhardt to approve this application with the limitation, I'll feel comfortable voting yes, but it's a close call. Thanks.
You have any comments?
No, the only thing I would add is I think it's important that Mr. Zorns appreciate the support that he has, and the fact that his employers are here supporting him carries a lot of weight with me in my mind.
I believe Chair Tagliati's point regarding what I believe is failure to cooperate and comply with instructions that were very clear. It's, to me, things like that are in the aggregate and they're troubling for me. And I took greater weight. It was, to me, I took it as greater weight in terms of the Wolves and their comments and their concerns and how they felt, because they were the employer that was wronged, and they described him as unethical, and they don't want him to be licensed. So those things, to me, and not whether or not a criminal charge was lodged, I know that was looked into, that's not the standard in Nevada. That's not the standard that I'm required to adhere to under NRS 463-170. I look at the qualifications for licensure and finding suitability for approval, and that's Mr. Zorn's burden. And the license must not be granted unless the commission is satisfied that the applicant is a person of good character, honesty, and integrity. And I don't believe he is, and I am not comfortable moving forward. I appreciate that the market is small. He does great work for them now. He doesn't have the ability to do the things he used to do before. Maybe he doesn't know everybody and he's not inviting people to the house to do things for him because the house is done. I don't know. But the justifications are troubling. Everything is, well, yes, but I did get a benefit, pulling teeth to get him to say that. I don't think he has good character or is honest or has integrity. So I don't think he's met the standard under NRS 463-170. So I'm not comfortable moving forward at this time.
I just have one final comment with the motion pending. Mr. Zorn, assuming this commission is prepared to grant this, take heed on what you've heard today. Because when you come back in 2 years with your with your application, if there's any suggestion of any, we'll call it issues with the issues that were raised here or other issues, I think you're going to have a decidedly different outcome.
And I know that this is privilege, it's not a right.
And for the record, I don't believe Mr. Zorns will ever have another issue going forward, but because of the 12-year history, and I appreciate Mr. Reinhardt, these little things, but they aggregate, and over time it goes to character and honesty and integrity. So I don't think we're ever going to have an issue with him again, but that to me is just not enough, especially when the enforcement side said, don't do something, and he did it, and I'm concerned about data being wiped. Allegedly, these are all things that are very troubling to me. So I understand that they need somebody to run the place, but that's not my standard.
Well, I would simply say that as much as my colleagues give a lot of consideration to the new employer and Mr. Reinhardt and your business, keep in mind that you do so at your own peril, because whatever the support that you have for him is great for him and apparently good for your business. But if there's some violation that isn't related to something like this and it affects your license, you went in with open eyes, and I'm thinking there's not a lot of forgiveness for you if it's as a result of his conduct, right? So you do that at your own peril when you stand up here and you support him and you see that history and all the concerns that Commissioner Brown has. So in light of that, I think is there any other comments or questions? All right. So just for the record, whoever made the motion, which was Commissioner Solis Rainey, I believe at the start of this, it was brought to my attention that the 2-year limitation recommended by the board was not actually stated into the record. Is that correct, correct, Madam Secretary?
Correct.
Okay, so that was brought to my attention. And so so if you were to phrase I don't recall if you phrased your motion as read in by Madam Secretary, but if you did.
I added the 2-year limitation. She'd mentioned it as well.
Okay, thank you. Thank you. I just remember that. All right, so we have the motion. Are we prepared to vote? Yes. All right. Perhaps we should do it individually because I think we're going to have some different votes here. So Commissioner Keycapper?
Yes.
Commissioner Solis Rainey?
Yes.
Commissioner Brown?
Nay.
Commissioner Cohen?
Yes.
Well, it appears that regardless of what I do, it will pass. I'm very concerned, but I'm going to go with the majority on this and give Mr. Zorns the limited 2-year conditioned opportunity to perform for his employer in an ethically appropriate way. Thank you.
Thank you very much. We appreciate this. Appreciate your time. Appreciate your concerns. And thank you again.
Thank you.
Good luck. You mean 7? Let's see. You mean 7? Right?
Yes.
Madam 7. Madam Secretary, please read in non-restricted number 7.
Non-restricted number 7 is the application of Konami Holdings Corporation for an amendment to their order of registration. It is also the application of Konami Australia Pty Limited for a transfer of interest. Lastly, you have the application of Konami Gaming Inc. for registration as an intermediary company and for licensure as sole shareholder of Konami Australia Pty Limited. The recommendation of the Gaming Control Board is for approval, and I believe we have a recusal on this item.
Thank you so much. My law partner, esteemed law partner, Glenn Light, at the law firm of Lewis Roca, is representing the applicant today, and I must therefore recuse myself from voting on this matter, and I will step out. Thank you.
Thank you. Good morning, morning.
Good morning, Chair Togliatti, members of the Commission, Madam Secretary. For the record, my name is Glenn Light with the law firm Lewis Roca, and I'm joined at the podium by Tom Gingoli, who serves as the Executive Vice President, Chief Operating Officer, Secretary, and a Director of Konami Gaming Inc. In the audience are Masami Sasso, who is a Senior Vice President of Corporate Planning, Manufacturing, and IT, and is also a Director, and Laurie Oak, who is the Vice President of Regulatory Compliance. As discussed at the board hearing, the application is straightforward. First of all, we request that Konami Holdings Corporation be renamed Konami Group Corporation. And second of all, we request permission to revise the internal ownership of Konami Australia Limited. With that, we're happy to answer any questions that you may have.
We'll start with Commissioner Cohen.
It's a very simple application as far as I'm concerned. It's straightforward. I understand the business reasons for doing it. I have no questions.
I don't have any questions either. It was pretty straightforward. With respect to the draft that you're on, I just wanted to confirm you're on draft number 1,
Correct.
dated 7/8/22. Okay, thank you.
Commissioner Keycover, do you have anything? I additionally, after reviewing the materials, have no questions, and at this time, it appears this matter is appropriate for a motion.
I move for approval of non-restricted agenda item number 7 as read into the record by Madam Secretary and give authority to the the Commission Chairman to execute draft number 1 dated 7/8/22.
Any discussion on the motion? There being none, all in favor, say aye. Aye. And there are none opposed. The record should reflect that Commissioner Brown did not participate in the discussion or deliberation on this item. Thank you. Thanks for your patience. All right, Madam Secretary, I believe that brings us to our restricted items held out for discussion. Please read in restricted number 1.
Restricted number 1 is the application of MFE Inc. doing business as Circle K number 2622004 for a restricted gaming license. It is also the application of Gurpal Kular for licensure as a director. The recommendation of the Gaming Control Board is for approval with conditions as noted on the agenda. I believe we have a disclosure on this item.
Thank you, Madam Secretary. Mr. Kular is adverse in a matter where I am in the process of being retained at the law firm of Lewis Roca. I'm a partner at that firm, and it's an unrelated matter to what's appearing before us today. I have no pecuniary interest in the outcome of this agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. Thank you. It's just a disclosure for the record. Thank you.
Okay, still good morning.
Good morning.
Thanks for being here today. We have your application and materials and information before us, and we also have the benefit of the previous appearance that you made to the board. So at this time, if there's anything that you'd like to say before we ask any questions that we might have, now is your opportunity. Or if you just want to introduce yourselves.
Yes, my name is Gurpal Kular of MFE Inc.
I'm Gurdev Kular, and this is our mother.
Maria Fernanda Enamorado.
So unless there's anything that you want to say before we open it up to questions, do you have anything in particular you wanted to address to the commission?
No.
Okay. So at this time, do any of my colleagues have any questions? Okay, Commissioner Solis-Rainey.
Thank you. I watched the Gaming Control Board meeting and read the materials. I understand that there was an issue with you adding, and I'm sorry, you both have the same last name. So you added Gurpal prior to obtaining approval, to add him as a director. Now I understand from the board meeting that the explanation was that you believed he had been submitted for approval for finding a suitability in conjunction with another matter on behalf of Bouquet Inc. Is that correct?
Correct.
Okay. That approval was obtained on July 24th, 2014, correct?
Correct.
So you believe that at that point he was approved for both?
Yes.
The timing of that is what raises this question. That was approved in July 24th, 2014, but he was added in 2013. So what was the rationale for you believing he was added before he was even approved?
We had counsel at that time filing those applications for us. They obviously these applications are submitted 6 to 10 months in advance. So I think that it just occurred with the timing of they handled adding for Paul to the corporations and also filing the applications.
Right. But I just want to make sure it wasn't clear to me during the board meeting that you understood, that either of you understood that even assuming that that was correct, that he was being, the application being submitted was on behalf of both entities, you still wouldn't have been able to add him until it was approved. You couldn't have added him beforehand.
Like I said, we had counsel at that time. We were, using them to advise us on the process and what to do next and what to provide.
I understand that you had very able counsel, and I have no reason to doubt that he would have advised you to exactly what I just mentioned, that the approval has to precede the actual transaction. So for you to use that as an excuse concerns me. One, because I know he's very capable counsel. Jeff Silver has been doing this for many, many years, and he would have been intimately familiar with the requirements. And to the fact that, even if you believed he was applying for both, you hadn't obtained the approval, so you shouldn't have added him beforehand. And that's a violation of the regulation. So I just want to make sure that you understand the seriousness of, not following the regulations.
Yes, we understand and apologize for the mistake that we made.
Thank you. I don't have any other questions.
Commissioner Brown or Cohen?
None.
Well, I think Commissioner Solis Rainey did the heavy lifting on the questions. We just need to have assurances that, that you understand that you've got to comply and be, if you have any confusion about what you need to do, there's an entire staff of people that I'm told over and over at these hearings are very professional and courteous and are willing to assist licensees with basically what they need to do. So hopefully you'll avail yourself of those that support if you need it. But I think you understand it now. So at this point, it doesn't appear that anyone else has any questions. So I'm going to ask for a motion.
Yeah.
Did we not read those in? I'm sorry, I did. Yeah, she did.
Hey, Madam Chair, I would make a motion that we approve restricted item number 1 as read into the record by Madam Secretary and recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
It appears there are none opposed. Thanks for your patience today.
Thank you.
Thank you. Madam Secretary, please read in. Yeah, our box is gone. Please read in restricted number 3.
Restricted number 3 is the application for licensure of Dr. Duck LLC to receive a percentage of gaming revenue from Sartini Gaming LLC, doing business at Nevada Ugly. It is also the applications of Lene LaValle Hunter and Thomas Hunter for licensure as a member and manager. The recommendation of the Gaming Control Board is for approval.
Good afternoon, Madam Chair, Jeff Donato, members of the commission, Madam Secretary, Jeff Donato here with Argentum. With me today, joining from Carson City is Mr. and Mrs. Hunter. They are the applicants before you today. If you would like, I can give you a brief explanation of the application and give them an opportunity to give them some information about themselves.
Perfect. Thank you.
So back in 2012, the Hunters opened up a tavern location in Gardnerville, Nevada. This location, no one under the age of 21 is permitted, and there's no restaurant within the establishment. There's currently 5 machines. Then several years later, they decided to get gaming at the location in 2015. That gaming is still operational today, but it's under a space lease where the slot route operator holds the gaming license. So now here we are before you today, and then now they're seeking approval to participate in the gaming revenue. So if approved, then that agreement with slot route operator would convert to participation, and they would start sharing in the gaming revenue. So with that, we give the Hunters some time to give some information about themselves. Renee, if you would like to go first.
Okay, hi. I don't really know what to say. I just
Could you do me
been
a
waiting
favor,
long
ma'am?
Yeah.
Ma'am, could you start over and speak right into the microphone and speak up?
Okay. I'm shy, sorry.
That's okay.
I'm Lene Hunter, and I manage the bar. And we've had the gaming in there, like he said, since 2015. And we went down the road of trying to apply ourselves. We did not do well. So we were informed we should get Jeff Donato, and he has helped us to this point. And so we're just hoping for approval.
Did you want to have it?
Yes, Mr. Hunter, if you would like to give some information and background about yourself as well.
Well, I'm a pharmacist. I've been a pharmacist for the last 26 years. I'm also a veteran, a 10-year veteran. And yeah, we're just trying to expand what we've been doing for the last 10 years. And we're looking forward, and hopefully with your approval, go down this road.
Okay, so we have a little trouble hearing, but hopefully there's enough volume there to get a transcript. At this time, I'm going to ask my colleagues if you have any questions for the applicants. Commissioner Cohen.
A serious question for Mr. Donato. Dr. Duck LLC. How did that come about?
I was not involved in that. I'll let
No.
the hunters explain that for you.
Yes, sir. I had a nickname when I was in the military, and it's a long story how I got it, but I was a medic. I was an EMT, and I just got a nickname, Dr. Duck. And as far as the Nevada Ugly part, we're in a building that was built in 1897, and it's called the Ativan Hotel. Well, Ativan is Nevada spelled backwards. So instead of calling it Ativan the Beautiful, we decided to call it Nevada Ugly.
I guess that
satisfies my concern.
Commissioner Brown.
Mr. Hunter, how much time do you spend at the establishment versus working as a pharmacist right now?
Give me a second, they're having audio issues. Give me 1 second.
That's okay.
Should be good now.
Mr. Hunter, can you hear me?
Now I can.
Okay, this is Commissioner Brown. How are you today? Thank you for coming.
Thank you.
Could you tell me, Mr. Hunter, how much of your time do you spend working as a pharmacist versus working at the establishment?
I'm a full-time pharmacist. As far as working at the establishment, I will maybe fix a leak in a faucet, but that's about as far as it is.
Thank you. And Mrs. Hunter, what is your role?
Everything.
Good answer. I have no issues, I have no reservations. Thank you for your time.
Any other questions or comments by our commissioners on my right? I mean, yeah, my
I
right.
don't have any questions. Mr. Hunter, thank you for your service.
It was my pleasure, ma'am.
Okay, thank you both for being here in Carson City today. At this time, it appears this matter is appropriate for a motion.
Madam Chair, I move for approval of restricted item number 3 is read into the record by Madam Secretary and recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
It appears there are none opposed. Thank you very much for being here today, and counsel for your patience.
Appreciate that. I'd like to thank Agent Jeffries for all her hard work during the investigation process.
Thank you.
Thank you.
Thanks.
Madam Secretary, next agenda item, please.
The next item on the agenda is the consideration of the placement of Kendrick Lorante Weatherspoon to the list of excluded persons, case 21-05.
Okay, so before we hear any presentation, I was hoping to ask a few procedural questions so that I have the context of hearing any understanding kind of since I'm the new chair and I'm not privy to previous placement on the list process. If you don't mind, can I ask just a couple questions to start?
Absolutely.
All right. By the way, go ahead and state your appearance.
Mike Somps with the Attorney General's office.
Okay, so just so that I understand, how do potential persons get brought to the attention of the board, the commission?
So generally, it comes up through the enforcement division. In my presentation, I will speak to that with this particular individual, but enforcement does do an investigation, and from there, it rises up to the board deciding whether or not to nominate the individual.
And do you have a working knowledge of the list itself as far as the genesis of those people coming from enforcement or elsewhere? Well, is that something you could speak to today or no?
Well, with the chief's help, I can.
Okay.
Chair, may I ask a quick
Oh, no,
question?
one more.
Oh,
Oh,
okay.
I'm not, sorry. I don't get to talk much because I'm always at the end. So I'm going to ask, as far as the confidential section of this, you know, kind of enlighten me, if you would, on how how that request is being made. You know, I've had other circumstances where the Office of the Attorney General has told me that anything that's presented to the commission is subject to being questioned and commented on and referred to by statute. And so I'm very sensitive in light of my previous professional background to the NCIC limitations of public dissemination of certain information. I get all that, but there's a lot more in here in this confidential section than, I mean, some of them are, so as far as your request to keep it confidential, anything in the exhibits, before we start our hearing and we're referencing someone's history or something, I guess I need to know and understand how far is it that you're asking us to go in confidentiality, meaning don't post it on any public, website, meaning don't talk about its content. Enlighten me on what you're asking for when you designate something exhibit 16 with exhibits A through M that includes a lot of things. Confidential.
Yeah, I would ask that the entirety of that exhibit, which is the affidavit of the board enforcement agent, along with all of the attachments, which contain a lot of personal information regarding victims, social security numbers, addresses, names, things of that nature. So because of that, I just ask that the whole affidavit and its attachments be kept confidential.
But you're not suggesting that as you go through your presentation or we ask questions, that is obviously, I think we're all pretty sophisticated enough to be sensitive to personal identifying information by law, actually, victims' names, that kind of thing. But actual facts underlying arrests, convictions versus arrested charges, that kind of thing that are replete throughout here, you're not suggesting that remain confidential?
No, and in fact, I will be in my presentation going over some of the allegations that were made or contained in the police reports that are part of of that particular exhibit.
Okay, so as far as what you are asking us to not comment on publicly would be personal identifying information, names of victims, any NCIC arrest records. I don't know. I mean, as tangentially referenced.
Right. And there isn't actually an
right.
NCIC record in there.
Okay, I just wanted to make sure that I set the parameters from my mind for what we get to, be asked to keep confidential versus not.
Sure.
Okay, so he has a presentation. Do you have something beforehand?
Just a quick question, if you could include in your presentation the composition historically of this nomination for exclusion. What is it composed as? Is it usually people who cheat in gaming, or is it somebody with this type of a record? Because it's not really cheating based. It's, I think, violence and felony and drug charges based. So I just want to see how it compares historically with the composition of the existing list to which the chair referenced.
Yeah,
You can include that.
I will address that. And of course, obviously, if you have any questions beyond that.
Thank you.
Okay. So again, my name is Mike Somps. I'm with the Attorney General's office, and I'm here on behalf of the Gaming Control Board. And I'm here regarding the matter of the exclusion of Kendrick Lorante Weatherspoon from licensed gaming establishments. This is not a contested hearing today because the hearing was not requested by Mr. Weatherspoon. And I don't believe he's in the audience, so you can confirm if you want, but if he was, you would be able to hear from him at your discretion, but I don't believe he's here today. Nonetheless, the commission must still consider the board's nomination and decide whether to place Mr. Weatherspoon on the list of excluded persons. So with your permission, I'm prepared to make a presentation. I'll create a record that supports placing Mr. Weatherspoon on the list of excluded persons. So first, as we've alluded to, there is a packet of exhibits that have been prepared, and hopefully each of you have copies that have been provided to Madam Secretary. I will be going through these exhibits, and at this time, if you'd like, Madam Chair, we can do it at the end. I'd ask that they be admitted and made a part of the record, and as we discussed, that Exhibit 16 be made a confidential exhibit.
So procedurally, when we admit an exhibit, it becomes a, public record. Exhibits 1 through 15. And then Exhibit 16 is deemed a confidential document and admitted. Okay.
And just one other comment on Exhibit 16. It is the enforcement agent's affidavit, and that details much of Mr. Weatherspoon's criminal history. And it also links Mr. Weatherspoon up as the same individual for all the convictions and arrests that I'm going to be discussing today. So with those exhibits admitted, my plan is to first provide some background information for the commission's benefit. And then second, I'll review the grounds for including Mr. Weatherspoon on the list. And then finally, I'll have some concluding remarks. There are some individuals here that I'll introduce you to, and they'll be available to you to the extent you want to hear from them. And then, of course, answer any questions that you might have. So first, some background. The matter before you today requires the commission to make a determination of whether the presence of Mr. Weatherspoon in a Nevada gaming establishment would pose a threat to the interest of Nevada or to licensed gaming. Back on January 5th of this year, the Gaming Control Board entered an order of nomination finding the presence of Mr. Weatherspoon in a licensed gaming establishment does in fact pose a threat to the interest of Nevada and to licensed gaming, and that he should therefore be excluded from licensed gaming establishments. If you look at Exhibit 1 in your packet, that is a copy of that order. Now, after the board nominated Mr. Weatherspoon, he was then served on February 8th of this year with the board's order of nomination and a notice of candidacy. That notice is Exhibit 2 in your packet. Service was accomplished by way of Mr. Weatherspoon's criminal defense attorney, who agreed to accept service on his client's behalf. That is Exhibit 3 in your packet. He was also served by certified mail with these documents on February 16th, and that is Exhibit 4. Mr. Weatherspoon had 30 days from service to request a hearing before the commission. We're obviously well beyond that period of time, and as I indicated, no hearing was requested. Separate and apart from the service requirements under the Gaming Control Act, the open meeting law does require notice to Mr. Weatherspoon that this matter was going to be on this commission's agenda today. So in compliance with the open meeting law, Mr. Weatherspoon was provided written notice, and I will provide Madam Secretary with evidence of that at the end of today's meeting on this. So then moving on to the grounds for including Mr. Weatherspoon. These are summarized in a bill of particulars that is in your exhibit packet at Exhibit 5. So pursuant to statute, the list may include any person whose presence in a gaming establishment is determined to pose a threat to the interest of Nevada or licensed gaming or both. In making that determination, you may consider the criteria set forth in NRS 463.151 sub 3. Pursuant to Regulation 28.010, if you determine that any one of those criteria are met in that statute, you can include Mr. Weatherspoon on the list. For Mr. Weatherspoon, he satisfies 2 of the criteria for inclusion. 1, he has been convicted of crimes which are felonies in Nevada. And secondly, he has a notorious or unsavory reputation that would adversely affect public confidence and trust that the gaming industry is free from criminal or corruptive elements. So first, I'm going to go through his felony convictions, starting with those convictions furthest in his past. So if you look at Exhibit 6, that's evidence that Mr. Weatherspoon was convicted in Nevada on December 5th, 1996, of possession of a controlled substance with intent to sell. That's a felony. Next, at Exhibit 7, that evidences that on September 19th, 2001, he was convicted in Nevada of, possession of controlled substance, cocaine, which is a felony. Looking at Exhibit 8, it evidences that on December 2nd, 2002, Mr. Weatherspoon was convicted in Nevada of possession of a controlled substance with intent to sell and ex-felon in possession of a firearm, both felonies. And then Exhibit 9, that shows that more recently, on August 4th of last year, Mr. Weatherspoon pled guilty in Nevada to 2 counts of coercion, and that led to his most recent convictions on February 17th of this year, when a judgment of conviction was entered, convicting him of 2 counts of coercion. You can find that at Exhibit 10. You can also see in that judgment of conviction that Mr. Weatherspoon was placed in probation, and one of the terms of that probation is that he cannot go to the strip corridor. I think it's also important to note for these latest convictions that court records show that Mr. Weatherspoon was at one point facing charges of burglary, kidnapping, sex trafficking, battery by strangulation, and sexual assault. That's contained at Exhibit 11. Now, for this conviction, I'd also like to highlight some of the details that led to the charges and ultimately the conviction. Allegations were made by the victim against Mr. Weatherspoon by a female who said she had first met with Mr. Weatherspoon at a Las Vegas casino. She alleged that they communicated for a few months, and then he eventually convinced her to be a prostitute for him. From there, they both went to another Las Vegas casino on the Strip, and he instructed her to engage in prostitution there. However, while there, she changed her mind. She decided she didn't want to do that. Mr. Weatherspoon, unfortunately for her, had been following her, and when she returned home, she alleged that Mr. Weatherspoon was there, and he proceeded to grab her by the throat, he shoved her against the wall, and he lifted her into the air, so much so that she couldn't breathe. She alleged that he also punched her a number of times in the head, where she eventually blacked out. When she came to, he sexually assaulted her. This information is evidenced in Agent Garcia's affidavit, as well as Attachment A to that affidavit. So the criteria in NRS 463.151 subsection 3A that he be convicted of felonies in Nevada is satisfied. Now, going on to the second criteria, Mr. Weatherspoon's notorious or unsavory reputation, which would adversely affect public confidence and trust that the gaming industry is free from criminal elements or corruptive elements. So, of course, all of those described convictions are evidence of Mr. Weatherspoon's notorious or unsavory reputation. But that's not all. Additional evidence of his unsavory reputation is his extensive criminal history that's described by Agent Garcia in his affidavit. And that, in addition to the convictions I've already described, includes allegations regarding his activities at Nevada licensed gaming establishments that suggest his involvement in sex trafficking, and that includes arrests and convictions for instances of violence against women. Now, to offer some additional detail of his reputation, I'd like to go through some specific examples of Mr. Weatherspoon's misdemeanor convictions that are worth highlighting, and that show his propensity for violence and provide additional support for Mr. Weatherspoon's criminal activity in and around gaming establishments. So in July of 2019, Mr. Weatherspoon was convicted of misdemeanor domestic battery. Evidence of that is Exhibit 12. Additional details are provided through Agent Garcia's affidavit and Attachment B to that affidavit. The victim of this particular crime alleged that she was a prostitute for Mr. Weatherspoon and that he had punched her in the lips. Just a few months prior, in May of 2019, Mr. Weatherspoon had another conviction for misdemeanor domestic battery. That's at Exhibit 13. Exhibit 14 is a certified copy of the amended criminal complaint for this case. It also shows that Mr. Weatherspoon was initially facing charges of sex trafficking, and accepting earnings of a prostitute. The details behind this conviction can be found again at Agent Garcia's affidavit and attachment C. The victim for this particular crime is the same as the one for Mr. Weatherspoon's July 2019 conviction, and she again alleged that she was a prostitute for Mr. Weatherspoon. She alleged that she and Mr. Weatherspoon were in an argument over the amount of money she made for him that night. She also alleged that he threatened to take her kids away if she didn't make more money, that he punched her in her nose, kicked her in her abdomen, and had thrown her to the ground. With this conviction, it's also important to note Mr. Weatherspoon's tie-in to gaming, as the police report reflects that prior to the battery, the victim and Mr. Weatherspoon had been arguing in an Uber driving them from a Las Vegas Strip casino. Finally, in November 2009, Mr. Weatherspoon had another conviction for misdemeanor battery domestic violence. That's Exhibit 15. Again, the details are contained in Agent Garcia's affidavit and attachment 9. Now, beyond these convictions, there's also examples of arrests of Mr. Weatherspoon showing his nexus to gaming and that add to the picture of his unsavory reputation. In 2016, Mr. Weatherspoon was arrested when the victim alleged that he followed her into a Las Vegas Strip casino and into the women's restroom while yelling at her and attempting to drag her out. The victim alleged that when she ran out of the casino and onto Las Vegas Boulevard, Mr. Weatherspoon caught her and placed her in a headlock. Again, details in the agent's affidavit and attachment F. In July 2013, Mr. Weatherspoon was arrested for grand larceny based on an allegation that while at a Las Vegas casino, he stole $1,000 in chips belonging to another blackjack player. That's attachment G to the agent's affidavit. In June 2013, Mr. Weatherspoon was arrested when the victim alleged that while she and Mr. Weatherspoon were at a Las Vegas casino, he wanted to leave, but she didn't. So he picked her up and carried her to the car where she claimed he proceeded to punch her in the face. Details in the agent's affidavit and attachment H. Now, Mr. Weatherspoon has also been trespassed from a number of Las Vegas gaming establishments in recent years. This is described by Agent Garcia in his affidavit. In addition, on one occasion, Mr. Weatherspoon was arrested in 2017 for trespassing at a Las Vegas casino following a police investigation of a grand larceny trick roll, where the suspected prostitute was detained while attempting to get in a vehicle driven by Mr. Weatherspoon. The suspected prostitute is the same person as the victim of Mr. Weatherspoon, where he was convicted in May and July of 2019 of domestic battery. Again, I'd refer you to the agent's affidavit for more details. And I finally want to note that Mr. Weatherspoon continues to pose a threat to the interest of Nevada and licensed gaming, as his last known address continues to be here in Las Vegas. So with the proceeding, NRS 463.151 subsection 3C is satisfied and forms that second basis for including him on the list. And again, establishing any one of those criteria is sufficient for placing him in the list. And Mr. Weatherspoon again satisfies too. So that covers the legal grounds for including Mr. Weatherspoon on the list. Statutory provisions are met that allow you to add him to the list if you choose to do so. So the question becomes, is that what you should do? And I recognize, and the board recognized when it considered this matter, that placing Mr. Weatherspoon with his type of background is unique. But I want to say that including someone on the list with this unique background as compared to others on the list is not unusual. The list has always evolved. The types of individuals placed on the list over the years has changed depending on the problems of the time, whether it's in connection, those that have connections to organized crime, those that are slot cheats or cheating at other gaming activities, or those that are using the gaming establishments as a place to steal from patrons. The list has been used for all those different purposes, depending on the issue of the day. And I think the legislature wisely created a structure that recognizes and allows for that evolution. Today, others can speak to this much better than I, but today prostitution and sex trafficking are increasingly problematic in Las Vegas casinos. And I can tell you that because of that, Las Vegas Metropolitan Police Department has sought help from the board addressing the problem through placing someone on the list with that type of background. The enforcement division of the board was open to that idea and decided to test the appetite of the board and obviously now the commission to use the list of excluded person provisions for that type of individual. Metro ultimately proposed Mr. Weatherspoon, who, as I understand it, is one of the worst given his significant criminal history. He's an individual with plenty of arrests, charges, and convictions related to drugs, related to violence against women, related to sex trafficking, and he often makes use of casinos here in Las Vegas and had these very recent charges that included sex trafficking, making use of Las Vegas casinos. So ultimately, in making your decision, I think you have to take the picture that's provided to you of Mr. Weatherspoon through the documents you have and decide if this is the type of individual you want in Nevada's casinos. Does his presence pose a threat to the interests of Nevada and the industry? The board has answered yes. Obviously, if you answer yes, he will be placed on the list. And I think that a message will be conveyed that those who engage in sex trafficking and violence against women are not going to be allowed to engage in that activity in Nevada's casinos. And I also want to tell you that if you answer yes, I think that you may be seeing other individuals with this type of background before you for consideration to be added to the list. Now that concludes my presentation. As I indicated earlier, there are representatives here. We have Todd Fasula, the Vice President of Security for Wynn Resorts, and Captain Haas, I hope I'm pronouncing that correctly, from Las Vegas Metropolitan Police Department, who, if you want to hear from them, can speak to the problem of sex trafficking currently occurring in Las Vegas and on the Strip, and can probably speak to whether or not it's helpful to have someone like this on the list of excluded persons. I also have Chief Taylor from the Enforcement Division, who's here to help me answer any questions that you might have. Otherwise, that concludes my presentation. And again, I'd ask that this particular individual be placed on the list of excluded persons.
So if I could, I had 3 questions at the start of this. 2 of them, I'm not sure. I would like a little more specific answer.
Okay.
I guess I'm asking where the genesis of this person being brought to the attention of our agency came from, not like Metro, but a specific person, a division. I'm not thinking it's administration of the sheriff. So I'm just curious where it came from, a person.
And I apologize. I don't have the name of the individual. I'll defer to
asking that for
Chief Taylor.
How long have I been asking that, you think? I've asked that through channels of, and I've never really had an answer. So I thought today I would be able to get that answer. Is there a person or a, form you fill out? How'd that happen?
If I may.
Sure.
James Taylor, Chief of Enforcement. Good afternoon or morning, Commissioners and Chairwoman Tagliati. This name came to us directly from the Convention Center Area Command, Captain Pelletier at the time. These conversations have been had with Metro for at least a dozen years. I took over the Black Book back in 1996. I can think of several instances over the years that vice captains, vice lieutenants, Karen Hughes was one of the early ones that asked me if we would be interested in this, but it was Captain Pelletier that was the last one that asked us several years ago. I told him at the time that it would fit the criteria, but he would need to present us with who they thought was the worst, who would help them the most. I asked him to pick somebody that had instances in the casinos that we could show was truly a threat, and that once they identified somebody and put the package together, that I would pull the board and see if they would consider that. So this goes back to 2018 for this particular individual. We had our case is that old anyway, but of course with COVID and the more recent arrest of this individual, and he was in custody for a while, it wasn't until January that the board actually heard this case.
So 2018, the Convention Area Command, did you say lieutenant? I'm sorry.
It was Captain Pelletier at the
Captain.
time. Mhm.
Thank you.
But there were others in that discussion. It wasn't just him, it was Vice and,
Yes.
and others, but he was the one that,
When this person specifically was requested and presented to you, was by him at what time?
it was around 2018. I think he had one of his intelligence who worked with other areas of Metro, obviously, but I think one of his intelligence analysts put the package together.
And the other question I had that I didn't quite get an answer to, and I'm sorry to put you on the spot. If you don't know, just say so, but I guess as you probably know, how many of the persons on the list come from a genesis, a suggestion outside of our own investigators and people versus not?
Well, I can speak to my tenure. Of course, the list has only had 71 people on it in the history. So 11 of them were put in on the first day. That was in 1960. So there's only been 60 put in since that day. And I can speak to my time in 1996 when I was tasked with kind of, I don't want to use the word freshen up the black book, but nobody had been put in the list of excluded persons for several years when I was tasked with it. I did about 25 cases over a 7-year period, and 20 of those were nominated. Probably 7 of those came from Metro Intelligence or our other law enforcement partners. More recently, Joseph Moody was brought to us actually by the industry. Some consortium of security professionals brought his name to my attention. Of course, we had a number of cases on him as well, and so does Metro. That was in 2018 that he was nominated and put into the list of excluded persons. So it's not this is not unique in that way that allied law enforcement has come to us with names.
And so, because I'm not privy to the lengthy history that you have, and I would just kind of like the background. So for the persons on the list that you listed, how many of them are non-gaming related offenders, like, jump over the cashier cage with a gun and rob the cage type people, or some crime other than cheating, or something that we would have seen in the more recent.
Okay, so up to 1996, when I took over the list, at that point, it was all comprised of organized crime figures and cheats, basically. Mostly Italian organized crime. We did have 2 Hawaiian gang members that were kind of legacy members of the book. Since that time, we have nominated other organized crime figures. I think the last one of those was in about 2004, I think, was the last organized crime figure. So since then, it's been organized crime figures, casino cheats, bookmakers, and just thieves. Now, this is kind of a unique situation to have somebody with this kind of criminal background, but he's not unlike a lot of the organized crime figures that we did who had no criminal history in the casinos. They might have used the casinos to conduct business, but there were quite a few from other cities that would just come here, and they were nominated and placed in the list of excluded persons that had no gaming connection other than they were frequent guests of the casinos.
Well, slight differences in that, and I don't know if you're familiar with my background at all, but prior to this appointment, I was a district court judge for many years. As I know Mr. Fasulo he was chief of the jail when I was chief judge of the 8th Judicial District. I was a JP, I was a DA, and I ended my career as a prosecutor on the Special Victims Unit. So I'm very, very familiar with the sex trafficking in Las Vegas and in our state, actually, and the problems associated with that. I guess the question that I really am curious about, and because this is obviously a bad actor for sure. I don't think anybody's going to sit here and say, that we're surprised that you're here. I'm certainly not. I guess my question is, so there were 400 cases in 3 years in sex trafficking filed by the district attorney in Clark County, 400. And we're talking minors being brought to hotels, all kinds of things. And from what I was a little surprised to hear that he got on the radar before even this most recent case, the genesis of this case, because the offense date was in 2021. So at that time, he had to use a prosecution phrase, no cases that really stuck related to sex offending, as far as sex trafficking, pandering, living off the earnings, the kinds of things that you would see in a case or an offender like this. And so I'm just curious, what would be policy-wise, what is your vision in your position for the other 399 offenders that were filed between, because I'm going to guess that you don't have enough staff to possibly go through all those, the ones that are sex trafficking minors and bringing them to hotels, things like that, where, the girls are 14, 16, 17. Do we have the kind of staff to I mean, this is a very thorough, helpful investigation. We obviously don't take it lightly. And so I guess the question I have is, what's your vision of what policy considerations are this person versus that person? Minors are involved, recanting adults are involved, because obviously there's something happened here where the district attorney could not get a sex offense conviction on this particular. I mean, it's a non-sex coercion, which is you have the right to do or abstain from doing something, and you are forced to do something you have the right not to do. So that's not a sex offense. And so I guess the question is, what is the vision for the policy on who out of those 400 approximately cases filed from 2019 till I think it was end of 21, beginning of 19, that we would be looking at going forward? Because obviously how you handle one thing is how you handle everything. We have precedent setting concerns. And when I was a judge, at least I always wanted to treat similarly situated people the same. So what is your vision or policy vision on that?
Okay, so the boards before this constitution of the board have always wanted the list to be manageable, to be small, not like other states with hundreds of people on the list. I haven't had that discussion with this particular board, but they've always wanted the list to be kind of the worst of the worst. The ones that we can manage a list of 35 to 40, and that's all we've ever kept it, because as people are deceased, we take them off the list. And so that's why I went to Metro when they asked for this particular type of crime to be included, because they were having lots of problems with pimps who would hang out at casinos, and they would keep an eye on their women, but keep an eye on, others that were working for others, and it would created violence, like you, I'm sure, are aware. But also they would prey on tourists, and we, try to solicit them to come and work. And so that was the genesis of this type of individual to place on the list. Why him in particular? I'd have to turn to Metro on why him in particular, because I told them that we would consider something like this as we've done in the past, but we don't know this world. The Gaming Control Board, hears about it. And in every meeting I'm at, we hear about, the problems with human trafficking. There's even an article in the paper today with the U.S. Attorney, saying that this is a new focus for their office. So it is a problem on the Strip. It is something that we can address through this. But why this particular individual, I'd have to ask.
Yeah, I'm not criticizing that. I'm not opining on it. I'm asking what going forward, a vision going forward. There's 400 of these filed, right? And many of them might not get a no-op probation, right? So that tells me something, that as far as the district attorney here is not one to turn a blind eye to sex trafficking offenses, nor is our police. Know that for a fact. And I'm always very happy to see it, and think it's an important part of law enforcement to have specific detail, like Vice, be policing this and making sure no one should be subjected to observing some of the things I read in these exhibits happening in the casino, or being solicited when they're minding their own business, or any of those things. I'm saying going forward, if there's 400 cases, and some of them are going to be worse than him, no doubt about it, and some will be not as bad, maybe their first foray into sex trafficking, but I just am asking policy wise, that's the hard consideration.
Well, you set the policy, so it's, I guess after the discussion today, we'll know where
you
where
bring
we're
it,
going.
you bring it to the board
But-
and you bring it to, then
Yeah.
they bring it to us.
But
So
of the 400, we would look at, whether we would even do another one, I don't know, but of the 400, we would look at probably the worst of that bunch. And do they have a problem in the casinos themselves? Are there lots of instances like there was with this individual inside casinos? And are they a threat to the either public safety or public perception? But the NRS is clear that it's an interest of the state, not just gaming, but interest of the state.
well, I'm not precluding anyone from, I guess I'll just wait and see what my colleagues have to say. I guess, my guess is that Metro would tell us that a majority of the prostitution activity that's going on will happen in near or around a casino or gaming area. I'm certainly aware of that, personally from professional experiences and I guess common sense. I'm just saying that from my perspective, I do have concern about the 399 other cases that are going on where you have these folks that, and I think Metro would also concede these cases are very difficult. They're very difficult to get convictions and prison time because of the nature of the cycle of violence and the recanting and they're very difficult cases. So I'm not criticizing anyone from coming here. I just am suggesting that I'm curious as to going forward, how this would affect the business of the board and the business of the commission on this list. But that being said, I'm not going to monopolize your time and I'm going to open it up for questions or comments, starting, who would like to start? Okay.
Chief Taylor, if I don't want to put you on the spot, but the last person that was admitted to the Black Book was, I believe, in 2019.
18,
Was it 19?
18. There was 4 of the last 5 were part of the Bellagio craps scam, the $1 million.
We voted on one shortly after I joined the commission in 19. And I thought it was a similar one where they were kind of using the
I thought it was
casinos as
18,
their
but might be
personal playground
Yeah, sometimes they do take a while to actually hit
for it to go
your
through.
desk.
So I was just hoping you'd remember because I remember it being similar circumstances to this. I would like to hear from the industry representative that's here and from Metro. My concern, like Judge or Chair Tagliati, is that if it gets too large, if it's helpful, then definitely, from a policy standpoint, it's something we should consider. From a practical standpoint, if it becomes too large and unmanageable, then it loses its purpose. Having been in the industry, the 71 people that were on there in, there's probably less than that back then, but, when I was in the industry in the 90s, we had every internal auditor memorize those and, we kept a lookout for them. That becomes impractical. And surveillance obviously had these people all memorized and kind of had their faces memorized. That becomes less practical if the list just grows to an unmanageable level.
But
I mean,
I
I'd
do
like
want to clarify one thing, if I may. There's never been 71 on the list. That's a rolling number.
Right, it's the number.
Only
that they drop.
71 in the history. So it's always been in the 30s or
No,
high
I know.
20s.
We always celebrated when we could cross one off that we didn't have to look for anymore. No, but for me, I mean, I would have questions of the industry representative to see, how it helps them or would it create too much of a burden for them?
Good afternoon.
Good afternoon.
I'm Todd Fasulo. For the record, I'm the Vice President of Corporate Security at the Wynn. I'm formerly retired Assistant Sheriff from Metro. I retired in 2018. I think listening to the conversation so far, I would offer this. If I get where the chair is going with the questions on going forward, do you just put every single sex trafficker into the Black Book? I would say probably not. But I think the focus should be mainly around the violence that's associated with it. That's number one. And the level of violence that is continually perpetrated by these individuals, not just the one and done, they get a probation, they get out of the game, or maybe they just do smaller crime. I would look at it more from the larger violent people that continually engage in the behavior, and then number two, they continually do it in a gaming facility, which is what I think fits the statute more so for putting somebody into the black book, because it gives law enforcement, it gives the hotel industry, the gaming industry, and it gives you another tool in that larger wheel, a spoke in that wheel, to enforce the industry standards, and the hotels have the ability to stay in compliance with gaming law and regulation. I've witnessed this firsthand in my career. I've witnessed it firsthand since I left Metro and went to the resort corridor. I'm still actively engaged with my peer group on the strip. We all suffer from some of the same issues that are perpetrated by these individuals that are, just downright violent. And if it wasn't for a casino, if it wasn't for a hotel, if it wasn't for tourism, they wouldn't have the grounds to go do it as fruitfully as they do now. That's why I think it's a good tool to put the most violent offenders in this black book. When I started at Metro in 91, the city wasn't where it's at right now. We've got Super Bowls coming. We have F1 coming. We're not the, million person population anymore. It's 2.5 plus. This is a big focus to the hotel industry right now, human trafficking. Every corporation has put forth brand new policy and procedures to combat it. And the win is no difference. So I would just like to remind you of just the level of violence. And I know the chair in her past capacity is well aware of those issues that have come before her in the court. So I don't mean to sound, disrespectful in that manner, but I'm trying to emphasize that this should be strictly for the worst, the most violent criminal that preys upon a woman, and they become a victim through most of the time no fault of their own, and then they use the casino in order to facilitate that crime. And I'm happy to take any questions on that.
Well,
Thank you.
So it's one of those, my acknowledgement of the nature of the difficulty of prosecuting those offenses is because this is a coercion. It's as generic a felony as you can get, with a no-op probation. So meaning, sure. So when the case was negotiated from the very serious charges that were, when he was booked into the jail, a detective or an officer made their best determination based upon the recitation of facts from the alleged victim and any other witnesses they had of, okay, which crimes do I think those facts support and potentially the district attorney could charge? And they write them all out. And they can involve everything from restraining someone with the intent to commit a battery or a sexual assault, in which case it's a first-degree kidnapping, on down the line, right? They book them into the jail. Usually the district attorney reviews that, and because the vice detectives are very experienced, knowledgeable, oftentimes that list will match up exactly with what the district attorney charges, because the officers there tend to be long-standing officers who know what they're doing. So those will match up for the most part. Then that case goes through the system, and for a myriad of reasons that we've talked about, the case gets negotiated and reduced charges. And that will have a direct inverse relationship with the cooperation of witnesses, the availability of witnesses. The DAs just don't, negotiate cases for no reason, right? Especially when there are serious charges like first-degree kidnapping and the person's looking at, literally potential, depending on the nature of the case, life in prison, sexual assault. These are, offenses that are, we wouldn't be having this conversation because he'd be in prison. So what happens is it got reduced to a coercion, which is a lesser category of felony. It is a non-sex offense felony. And the district attorney took no opposition to probation before the sentencing judge. That was their position at sentencing.
No opposition.
No opposition. Judge, we don't oppose you placing this offender on probation. And so from the judgment of conviction, that's what happened here, is he was placed on probation in order to stay out of the corridor. 36 months. And I think because he hasn't had a trespass or a revocation, or else he would have told us. If he'd have been revoked from prison, I think we would know. Someone would know. So I don't know for sure, but I think someone would be able to tell us that. So that's what I'm referring to, is the case got.
I just understand the law.
That was a really long answer too. No opposition. Sorry. So anyway, I left off saying coercion, no probation, after he was brought to the attention. So that's what I'm struggling with worst of the worst, because the worst of the worst at the time he was forwarded as the worst of the worst had some DVs and now has a coercion, no probation. And I'm looking at just cases I handled that were with people that, were far as concerning. Let's put it that way.
We have one that at the time in 2013, I believe I was the captain at Convention Center Area Command, and we had the rolling shootout between two pimps coming down the boulevard that had left the casino, left 3 people dead, including 2 innocent people. That person's he's on death row. He is one of the worst, but it was for one offense. And with all due respect, I'd like to offer this about what you just said about the no-op. You're correct. These cases, and I'm not going to speak for Metro because I'm not there anymore. I'll let Captain Haas speak about it. But from my perspective, they are very difficult to prosecute. They're very difficult for the police to bring forward because of uncooperating witnesses. But that doesn't change the fact that the person has a propensity to show violence. And by putting somebody into a black book, you send a very clear message that, yeah, you might have got a no-op probation, but you've continually used our casino industry to facilitate your violent crime. And we're not going to let that go anymore. You're lucky you're not in prison for whatever those technical or legal reasons are that they're not there. But to say that he's not the worst of the worst, I don't know, because I'm not there anymore at Metro. I would imagine I have faith in the department that I come from, that they've brought forward who they really want to put on that in the book. But I think that because of the difficulty in prosecuting those cases doesn't negate the fact that you're talking about a very violent person that continually perpetrates those crimes in the casino industry. From being in the casino industry now, it is important to me to be able to enforce that if he's in the book. It keeps him off my property. It keeps, if he continues to engage in the sex trafficking, it keeps those girls off my property, which helps us stay in compliance all the way around to begin with. And it's the right thing to do, right? Human trafficking is at the forefront of a lot of conversation right now. This, like I said, is just one tool that will help us enforce that, whether you're on the gaming side or you're on the law enforcement side.
Well, that would be another interesting question. It was always a bad thing when a lawyer said, with all due respect. That was always like, oh, you knew something was coming. Right. It happens in politics. I don't have a history of hearing these matters before. This is the very first one, which is why I ask a million questions, because I want to know going forward how this works. Has the board in the previous, and I guess the commission, because you referenced a specific person and a case, an item, do you consider convictions versus charges, or because, and what is the evidentiary standard? So, hearsay is admissible and we rely on that. I think we have in all other proceedings, but this is an interesting difference. And so I guess I would say, is that something that comes up in the previous hearings? Can someone address that, maybe, if you were at the previous hearings?
Sure. Thank you, Madam Chair. Obviously, it depends on the criteria we're looking at. For the conviction criteria, we're looking to present you evidence of convictions. But when it comes to reputational type of that criteria, it could include arrests. So it's whatever goes to their reputation. And certainly it isn't always convictions.
And I would say that historically, and Chief Taylor, you can correct me if I'm wrong, but historically, a lot of the people that were initially put in the black book didn't have convictions because they couldn't get them convicted, was my understanding, pulling from pretty far out ago, but it was people that were involved with the mob at that time that, there was a lot of suspicion there, and maybe it's sometimes been arrests, but they just couldn't prove it. So therefore, we had to rely on the unsavory reputation.
I know since 1996 that everybody that we have nominated has had at least one felony conviction. For that, that might be true.
I do have one question about implementation and practicality. How will placing this person on the blacklist actually deter other violent, sex trafficking, violence against women, offenders who use gaming establishments to conduct criminal activity? How do you envision deterring them, if practically speaking?
I won't speak to how it practically will work. I'll leave that to the experts. But I can tell you, and you probably already know this, that the mere presence of someone on a non-restricted property who's on the list of excluded persons, they're guilty of a gross misdemeanor.
And that question goes back to my initial desire to hear from the industry representative in the Metro. That was, I'm sure I didn't phrase it properly, but from an industry perspective, how does it help you as opposed to simply trespassing this person?
So right now, if you are engaged in prostitution as a woman and you show up on property, it's a misdemeanor crime.
Right.
We know that those women are being trafficked by a pimp. The pimp is usually engaged in the felony behavior. The prostitute isn't engaged in the felony behavior until they commit a felony crime, such as a trick roll. If the pimp has a deterrent to not be in a casino because now he faces the gross misdemeanor for being in the black book, now the penalty becomes more stringent for him if he's caught on our property again. And it's widely published because it's public that who's in the black book. Whereas now you don't have, with the hotel industry, we don't always share information of who's on property, who's not on property with others. The black book, it gets shared with everybody. Everybody knows, so now there's a deterrent that's greater than what we currently have right now.
Okay, thank you. That's helpful. Just from a practical standpoint, I wasn't sure, that gave you a better tool than simply, trespassing him because he's a known pimp and has had these convictions.
Yeah, if we just trespass him, like if he walked on the property, I'm trespassing him the minute he walks on the property. If he's in the black book, now I'm getting Metro involved because it's a gross misdemeanor.
Correct.
And I don't have to worry about trespassing him because he's going to go to jail.
Makes sense. With respect to the question of going forward, if he's one of several hundred people that probably should be in there, because I don't think any of us are going to disagree that, human trafficking is definitely something that is become a problem and that it's become a greater problem. It's not something we want to encourage and certainly not something we want to allow on our gaming properties. But assuming, this list would grow larger because more and more individuals of this type would get added, how does that affect you from a practical standpoint of enforcement? I mean,
so if I understand what you're asking me, the way that it would help the hotel industry going forward is we keep record of everybody that's on our property that we've ever trespassed. We keep pictures of everybody that we've trespassed. And a lot of the hotels are now going to facial recognition, and we can use that to combat the minute somebody steps onto our property. If you've been to my property and a few others, we have license plate recognition. If you're there and you commit a crime or we trespass you and you're there in a vehicle, we put your license plate in our recognition system. The minute you pull into my garage, I know you're there. So it gives us, if you're in the black book or you get trespassed, I'm putting you into our systems. And if you step foot on property, now I can get to you much quicker than letting you engage in more criminal behavior. And then I don't find out about it until you've already committed the crime.
well, you've come a long way, so I'm sure that's easier than having people trying to look out for these people.
Yes.
So the quantity doesn't give you pause. My concern was that it would become unmanageable for you
No,
on
because
the property side.
I'm not gonna say that it won't. To be honest with you, I don't know that it won't. I think that you'll kind of plateau over time as the word gets out and we do a better job and law enforcement does a good job at enforcing and the hotel industry works together in unison with the police to help enforce this kind of stuff. I think it'll eventually plateau because the word will be out. And if the criminal justice system's on board, people end up with a good sentence because they've got the gross misdemeanor now instead of just a misdemeanor. Maybe we start to get more of a deterrence down the road. So it's hard to say. I mean, we have millions of people that come here every year. Yeah, sometimes it is overwhelming, but I look at it as this is the worst. This is the guy I definitely want to be on the lookout for because I don't want him in my property because somebody's going to be victimized.
Understood. Okay, thank you. That helps a lot. Again, I mean, I wouldn't want to support a policy that would create an impractical burden on the licensees to enforce, where failure to enforce and then subjects you to violations for not noticing that one of these individuals is on your property and allowing them to gamble or whatever it is that they may be there doing. So I just want to balance the two interests. So I appreciate your input.
You're welcome. I understand.
Thank you.
It's very helpful.
Question. There's nothing that mandates this commission, notwithstanding the compliance with 463-151-3A, to put someone in the black book. So we have to weigh a policy decision on whether this is appropriate. In exhibit number 10, judgment of conviction, plea of guilty on Weatherspoon. Number 2, stay out of the strip corridor. Do you have, I don't know if this is sensitive, but do you have Witherspoon in your database for any reason?
Not for committing a crime on my property. No.
Just you would have it because he is now a convicted felon who received probation. Now, if he comes on your property, you're going to get security's going to get flagged, correct?
If he comes on the property and we know of his presence on our property,
correct,
he'll be trespassed immediately.
Okay. And if you knew of the stay out of the strip corridor portion of his plea agreement, that could result in a revocation of probation. Don't we get to the same place? I'm trying to put you, the resort industry, in a position where, yes, we know there's deterrence, but not in a position. The worst thing that could happen for us is something happens with Witherspoon. He's in the black book, and you don't detect it. He just walked into the bar, something happened, someone gets in a fight. You may not have been able to act in time. So I'm troubled by what is it we're trying to accomplish other than that this type of thing will get you in the black book, when there's other things available that may get us to the same place and not utilize, historically, so give or take 31 people in the black book, which where you try and enforce, type of thing. If this thing jumps up to 100 over the next 5 years, does that mean an increase in the cost to the state on the enforcement side? Does that mean Metro's doing less and relying more on gaming enforcement? I don't know. I'm just not sure what the answer is. I know, I wish I could tell you that this is going to be the deterrent that is needed. I don't know. But I am concerned about issues that if you do this and it's not a deterrent, then where do we go?
I would suggest that, well, there's multiple questions in there.
There's multiple.
Which one do you want me to answer first?
Anyone you want.
So going back to if he steps foot on property and he's under an order out from the court, which would be a violation of a court order, which could potentially put him into a predicament that he's violated the conditions of his probation. We may or may not know that. Normally, if someone is trespassed on the property and they come back and we recognize them and we catch them either through personal identification between security and they just see them, or 2, they've used a form of identification for either gaming, rewards card, pay at a point of sale, something like that, we would take them into custody because they've been formally trespassed. Then Metro would make a decision once we call them whether or not they're going to take them to jail after they determine if it's been a lawful arrest or not. They would determine that the person's under an order out. We may or may not know it at the time. If he's in the black book, I trust me, everybody on the strip is going to know that he's in the black book and he's not allowed to be in a casino. So it's not going to be a question at that point of, okay, do we trespass him or do we not take him into custody? Do we let him go this time? It's an immediate detention, and we're calling Metro because we have a more significant crime than just a mere trespass onto the property. I hope that answers the part of that question.
It's helpful.
Just so that the penalty is a 90-day difference, really,
True.
because with good time, which I know you know better than anyone on the planet,
When the jail's at 100%
when
capacity.
the
yeah.
jail's at 100% capacity, which is
It's
all the
70
time.
now,
It's at what?
70
Okay.
roughly.
So if a judge were to sentence someone for violating trespass and the casino were to show up at a sentencing hearing and say he's the worst of the worst and he keeps coming back, the most they would get is 6 months with good, right?
Correct.
Okay. So it's technically 6 months difference, but with good time, it's a matter of, I don't know, 3 to 6.
Does the court communicate with the casinos on the strip about a stay out of the strip corridor order as a probation condition?
They would call P&P.
But
We would normally get it from Metro Records. All the hotels have the ability to call into Metro Records. They'll tell us if someone's wanted or if there's a condition that requires a police presence. But yeah, ultimately P&P would be the ones that would deal with it if Metro took that person into custody to deal with the probation violation.
I wish there was a way for the court system to communicate directly with the casinos to present the list on, I don't know, a monthly or weekly basis to say this person has a stay out of the strip corridor probationary requirement, because I think that would short circuit that.
We're actually working on that right now
Okay, I think
with the courts and the DA to facilitate that.
because then we could trigger the probation violation.
What's the fiscal note on that?
We don't know yet, but we're almost there.
Well, that would be great.
Software communicating with software, is that what it is?
Yes, and we've already got the approval unofficially to get it done.
So you may have flipped me on this one because you're making it sound easy, right? Like, why don't we just put every pimp and every sex offender into the black book, and that way you're gonna get them out of casinos entirely, right? Because you'll, through your license plates and your facial recognition, you'll know that they're on property. They'll be rang up on a gross misdemeanor and gone. I mean, can you handle 1,000 people in the black book? 2,000 people in the black book?
If the technology is on the property in order to facilitate that, then you probably could. But I'm not going to stand here and tell you that that's an easy task, because it's not. And I'm not advocating by any stretch that every single person that engages in this behavior get put into the black book. I only advocate for the ones that continually show a history of violence and they perpetrate their crimes through the casino industry.
I'm going to use the with all due respect, because I think that even if you don't punch somebody in the head, pimping them out is inherently violent.
It is.
I have a couple of different questions, but there was I think the chief made the reference to the item on, it was in attachment G. I think it was 2013 when he was accused of stealing $1,000 in chips. Did we not prosecute that? I mean, that's a gaming related felony right there, right? I don't know what happened there.
Yeah, there was not a conviction as a result of that. I'm not sure if gaming was involved in that particular case.
Okay. Are there license implications for licensee if they don't act on someone in their property on black?
There is, if they know that the individual is on property and they fail to remove them, they could be subject to disciplinary action with the board.
Has that happened?
Not that I'm aware of.
James Taylor for the record. I think there was an incident up at Lake Tahoe with Sam Giancana and he was responsible for the Chicago crime family and Frank Sinatra, but certainly nothing in the recent days.
All right, thank you.
Has everybody had enough? Have you had a chance to, have you had anything else? I'm sorry. What did you say, Agnes? You said you offered to have Metro come up and address the commission.
As I indicated, they're here if you would like to hear from them.
Sure.
That's Captain Haas.
Thank you.
Good afternoon, ma'am.
Hi.
My name is Captain Fred Haas. I am in charge of the gang and vice section at Metro. We've seen a lot of this violence with human trafficking, and it has exploded over the past couple of years, as you've indicated. This isn't a new issue, but it is an emerging and growing issue across our valley. What's increased also is the amount of violence. The amount of violence that these people use to get these females to work in that environment over and over again. And if they don't produce a certain amount of money or do a certain amount of thefts on these casinos, they're beaten. Sometimes beyond recognition. I have these photos that it pulls at your heartstrings when you see them. That violence goes beyond that relationship between the pimp and the victim of human trafficking. It also goes into those that are in the hotel rooms that pick these girls up because they've trained them how to drug the people that are coming to our hotels and steal their valuables from the hotel room. In 2021, that loss was about 2.3 million. This year so far, we're at $6.7 million loss on top of that. And 3 of those individuals lost their lives. So there's a cost of this beyond that. I also worry about these young women that are out there because they're not bringing them in from out of state. They're preying on our girls. They're preying on people like my daughter and our kids that are here in this community. And they're putting them out there to be abused. They're putting them out there to get trafficked because men think it's one legal here or that they're not going to get caught. I've seen, I have a 15-year-old young lady. She has been stopped 17 times by us from the same pimp. She is HIV positive. In the last 30 days, she had 5 of her teeth knocked out from him. I have not been able to prosecute because she fails to be a cooperative victim on the backside of this case. This is what we're trying to address with this. I am not trying to go after the 300 or 400 a year that are doing this. What I'm trying to go after is those that are very sophisticated in how they do this, that the coercion is beyond violence. It is beyond what we see in the one-offs or two-offs where they come out, think they're going to be a pimp in Vegas. We arrest them, they get their probation, they go back home, or they realize that we're not going to accept that behavior in our jurisdiction. I'm after the ones that are continual, year after year, and we get these victims over and over. And what I'm finding is new victims coming forward. It's not the same female victim coming forward day after day. That I'm getting 7 or 8 different females that are coming forward because of the violence. But they're more afraid of the violence than they are putting them in jail and getting help. And that's a hard pill for me to swallow, sitting in this vice unit and watching these girls get brutalized on a daily basis. We have to try something new to get these people out of our community and let them know that we're not going to accept that type of violent behavior here. And is there a lot of them? Yeah. Yeah, we have 300 some cases this year already, but out of those, I can only think of 6 or 7 that I have concerns because of prosecution, because it happens over and over and over again. Most of these, they take the conviction, they go back home, or we don't see them again on the strip or in that type of activity because we do spot check them on the backside of that. I do have cases that are in the court system that if they don't go well in the court system, that I could say, yes, that might increase that number slightly to increase what we would ask for from this board. But I have to find a way to protect these young women because it hurts. It hurts to see that every day. For my detectives, Catherine Huey's here. She's one of the senior vice detectives. She's been with us almost 10 years. I can't imagine how many victims she's seen and had to deal with day after day over and over again from this violence.
Sir, so on your list, you have identified 6 chronic repeat offenders whose tentacles of violence just continue to grow. It's about 6?
I would say about 6 is what I can come off the top of my head, thinking the 12 months I've been in this position. I would say if this could be a potential for us to go down this road if I am not able to get through the court systems.
And if we extrapolate with those 6 chronic offenders, how many victims are impacted by them?
Anywhere from 2 to 20. I've had some pimps that have had 20 girls that we've come forward and not been able to get one of them to come forward as a victim.
And so the reach of this potential decision could be could have serious ramifications in terms of helping keep gaming safe. in the state of
Absolutely.
Nevada.
Keeping our casino safe, the gaming safe, our visitors safe, and our girls, most importantly.
Madam Chair.
Go ahead.
I'm sorry. So within that vein, do you think you could feasibly work with our staff to write a policy over how we would categorize somebody to fit into this people?
And I'd be more than happy to be a part of that solution, sir.
What would something like that look like? Would it be
I
based
think-
on number of arrests, number of?
I think the arrest is even hard because I may not get that arrest because I don't have a good victim, but I can look at reports. I can look at amount of time and is it over a certain period of years? You know, I'm not looking for the one guy, I have one case and I never hear from him again. I'm looking at the guy have 6, 7, 10, 15 cases on him. But I'm sure we can find a policy in there and I'll work with the gaming commission to do that, to find that middle ground on what's acceptable. None of this violence is acceptable to me, and I have to find a way to combat that.
I appreciate that. Look, I think for the person in front of us, I'd rather have one of your guys follow him until he's on the strip and then bust him on his parole violation and send him to prison, right? Because that would be a better outcome for society right now.
So the issue with the probation, that's good for a year.
Yeah.
What happens when he's off probation? He's still doing this. Mr. Weatherspoon had a victim come forward 2 months ago, but she failed to be a victim. He is still out there victimizing people on these casino floors.
And you don't have to convince him of his character and where he works. You know, I think that if we go down this road, it could be slippery if we don't put some parameters around it. And I think the goals are clearly noble. I worry about not knowing where we're going yet. Leave it at that.
I'm very interested in putting on the list somebody that's this egregious. And I am concerned about the precedent that we're setting and opening the floodgates. But when you specifically identify 6 chronic offenders, it alleviates some of my concerns about the precedent we're setting and what's coming in the future. Thank you.
The thing I would be concerned about, and you know, it's not really this. I think hopefully from the tenor of my questions from the beginning, it's not this person, right? It's for me, it's process and consistency and practicality, and because it's easy to say this guy's a bad guy, put him on the list. I would have been done like an hour ago. Okay, that's not the issue. The real issue is, you know, I hope when you're looking at these cases and you're bringing them to us, hopefully you're being very mindful of the casino relationship, because I know that, you know, here there's an Uber driving away, you know, there's a domestic violence at home, but he's a pimp, right? And so there's a lot of like tangential, some of it's casino and some of it's not. And quite frankly, when this came to, from what I'm hearing in 2018, this whole coercion thing didn't even exist. So what it really was you all knew what you knew about broken ribs, violence, and all that stuff. But if we were to have this hearing in 2018, there wasn't a whole lot of linking up to anything to do with the casino. It was some trespasses, which, you know, look, their job is not easy. It's a, you know, we call the cops, they get removed, they're there the next day, they're there 12 hours later, they're 6 hours later. I mean, I'm sure there's a record. 4 hours later, I'm being told by Mr. Fasulo. It's a challenge. And, you know, and you got the mentally ill, you've got all kinds of problems, and we appreciate that, and I appreciate it. And my issue is, though, I've also, how long you been with Metro?
21 years, man.
Okay, so I'm just a hair older, just a little bit. just skosh, older than you, as far as in the system. And I know for a fact that sometimes there's more than one way to skin a cat when you can't get a charge stick. And I get that, and I understand, and but I guess I would be super mindful to suggest to our people and to you that if this isn't a thing where we can have 400 people on the list, and you're telling me, well, nobody wants that. But I guarantee you, out of those 400 cases filed between January of 19 and December of 21, there's some bad actors on there, maybe worse than this, that are bringing 15-year-olds. The case that you just talked about, my guess is that person's maybe a little worse, right? And so there needs to be that casino nexus, and we can't just be like a tool to make things happen that aren't happening otherwise in the justice system, which, while very frustrating, is the best in the world. Not perfect, though. I just had a general question that has nothing to do with this. And this is either for you or Mr. Fasula or both, any efforts to put some teeth into trespass as it relates to strip casinos? I mean, why? It's always been this. Nothing has changed since 1994 when I was a DA. Nothing has changed. It's a rotating door, and I was just curious.
So about a month and a half ago, I brought my peer group together along with some other people in the criminal justice world to hammer out that exact problem, because it is a cyclical, it's just a revolving door, and there's no teeth behind the trespass statute. And the way that the statute is written, there's no timeline for a trespass, but the courts have ruled that Metro can't enforce anything outside of a 12-month period. That needs to change. We recognize that. And then we need to get judges, the DA, PD, we need to get everybody on board on a reform of how we address trespass and the chronic issues that come with the people and it's just not the strip, it's all over the county, it's all over the state. But yes, to answer your question, there is some things in the works, and it's moving along very quickly and very well.
Oh, that's good to hear. I'm sorry.
Yeah, this is a question drawn from my lack of knowledge about certain things. Are there any criminal enhancements associated with the strip corridor or licensed properties as they currently exist? Can you get an enhancement for committing a crime specifically on a certain type of property, aka a licensed property that you're aware of?
No, there's no enhancement for where a crime occurs at, whether it's at a casino property, in a residence or street.
And Mr. Fazzulo, I think you'd indicated as a corporate entity have certain policies and procedures in place to try to address sex trafficking and prostitution on property. Can you talk a little bit more about what that looks like? Is that employee training? Is that like sort of safe harbor provisions where if someone approaches an employee and says, I'm being trafficked, that they're safely protected? Talk a little bit about that and what that looks like.
Great question. So yes, to all of the things you just said, there is a very robust policy that we pushed out at my property. It's actually corporate wide in North America. We roll it out here and we roll it out in Boston at our property there. Every employee goes through that training. It's in addition to just reading the policy. There's videos, there's indicators, how to identify indicators of human trafficking, what to do when you see those indicators. And then there's specific training just for security personnel on how to deal with that when the bartender calls us and says, hey, I think this woman sitting at my bar is being trafficked or is engaged in prostitution. Now security knows what to do with it. We also have specific signage in various parts of the hotel, especially in the holding rooms, that provide advocates and numbers for people to call to get the help. We will facilitate those phone calls as well as part of our policy. If we can convince the young lady to get out of the game, per se. So yeah, it's a very robust policy, and they spend a lot of time putting it together all the way up to the CEO level that put a message out in a video about the importance behind this issue.
I appreciate that. It doesn't surprise me that your company is taking that position and a leading role in that. I think that if we're looking at, as a commission, what we can do within our authority to really tackle an issue that is a problem within the properties that we regulate, but is also a broader societal. Maybe some regulation around this space would be appropriate, as well as seeing if we could get something in terms of a enhancement. And there might be differences of opinion on that subject, but look, if it's our job to protect the industry as much as possible, then finding ways to really tackle this outside of a deterrence from people who don't seem to have much problem committing really serious felonies to start with. It would be something I would certainly be interested in.
The record that's before us, I'm sorry.
I apologize, but Nicole says the court reporter was asking for a break a while ago. I'm sorry. Can you stick with us just like another 7 minutes? Okay, thanks. Yeah, I just had 7. Is this on? Okay, great. Thank you very much for sticking around. I know you had some questions. I apologize, we needed the quick break.
No problem. Thank you, Chair. Let me tell you where my head set is on this, and I can't speak for anybody else, on the commission. This is a horrible, horrible record. It's a horrible blight for the state of Nevada, and something has to be done. You've come to this commission, you went to the board, and now it's come to us. What I would propose, now this is not a motion, this is just where my head is. There's a couple things, the facts that have been presented to this commission make Weatherspoon a candidate. No ifs about it. He's a candidate under 463, 151, 3A. Number two, Witherspoon was served, as stated, by Deputy Attorney General Solms. He's been served. The attorney was served with documents. So he's had every opportunity to come in and contest if he so desired. Number three, there's been a lot of incredible conversation, and statements by the commission members about something more needs to be done beside whatever we do. We need help from the court system. We need help from Metro. We need help from the hotels. It can't be the burden of the state of Nevada enforcement to bring these people to us. So what I'm thinking, again, out loud is he is a candidate. He didn't file a response. He should be inserted in the black book, and hopefully it's a deterrent. But again, it has to be a case-by-case basis. We are not looking for, at least this is me, we're not looking for the floodgates to open for 300 people to be brought before us, because that just shows, as far as I'm concerned, the ineffective nature of what was done. So that's what I would propose. I will make it a condition if it goes that far, but Commissioner Keffer regarding Metro and the county and beefing up the laws, that's got to happen right away. These agencies need to talk to each other. They need to talk to each other. And I don't know whether there's any support for what I just said, but something's got to be done, because this is a horrible, horrible record, and it hurts. It hurts me to read about it. It hurts me to hear about it, let alone the people that were brought in, with Metro and and through WIN about how they see it every day. So anyway.
Are there any other comments, questions, anything at all? There being none. All right. At this time, does someone wish to make a motion?
I would like to make a motion, Madam Chair, if I may. I move to place Mr. Weatherspoon on the list of excluded persons based upon the criteria enunciated under NRS 463, 151, subsection 2, subsection 3A, and subsection C, because I believe we have sufficient evidence before us to make the determination, and considering all the facts before the record, including exhibits 1 through 16, and the prevalent violence against women demonstrated by Mr. Weatherspoon in gaming establishments, tangentially related to activities around gaming establishments, his reputation, his drug charges, his weapon charges, his felony related charges, sex trafficking, and using the Las Vegas casinos as a backdrop for his activity. And I think based on his prior convictions under subsection 3A of the statute, it falls squarely within the ambit of a prior conviction of a crime, which is a felony in the state under the laws of the United States, a crime involving moral turpitude or violation of the gaming laws of any state, and includes the issues that he had with shifting chips on the casino table, separate and apart from the violence against women, specifically in a casino, various casinos in the state of Nevada. Also, I believe his conduct falls squarely within the scope of subsection 3C of the statute, and he has a notorious or unsavory reputation, which adversely has affected the public confidence and trust that the gaming industry is free from criminal or corruptive elements. And I think that is the scope of my motion, unless somebody has any questions or comments, if I need to make any modifications.
Any modifications? Here's the thing. I'm comfortable with a motion to pursuant to certain, I'm comfortable with a motion pursuant to the NRS that you are the statute cited. The problem is all the other things. I'm a little concerned that there were some things that were charged, some things that were not charged, some things are convictions, some things are not convictions. So if I'm going to vote on that, I would like there was a lot of elaboration of commentary, and I'm not comfortable voting on that as a motion, if that's okay. So either if you want me to take a vote, I will on that particular motion. If you want to amend it to just streamline it to not include a lot of discussion of the nature of the charges, because some are in the police report, some are charged, some are not charged, some are convictions. I'm less comfortable.
Okay,
with
and I do apologize. I thought I was supposed to identify the criteria that were used in making the determination and create a record. And to the extent.
Well, then I'd have to get a transcript of the list of charges that you had. I mean, is there a?
So I identified and incorporated by reference exhibits 1 through 16.
Okay.
Noting that 16 was confidential. Attorney General Brian Egg, is it necessary for me to simply just identify the statute, or should I add specific reasons, as I understood that I had to identify using the criteria?
I think your reasons are noted on the record. For purposes of the motion, you can just identify the specific statutes that you are making your determination on.
Okay, thank you. So I will modify it accordingly. I move to place Mr. Weatherspoon on the list of excluded persons based upon the criteria enunciated under NRS 463-151 subsection 2, subsection 3A, and subsection 3C.
Perfect. I appreciate that.
I misunderstood the instructions.
No, I just can't remember all the charges and everything, and so I'm more comfortable with that language for me personally. So thank you for that. So there's a motion pending. Any comments, questions before I call for a vote?
Thank you, Madam Chair. I'll support the motion, but I do think we may have an opportunity to consider what more we can do to try to combat sex trafficking in our state through the powers that we have as regulatory body over casino gaming. And I'll think about it, and if you have any ideas, let me know.
Okay.
And the reason I made the motion is because I believe Nevada is no place for violence against women, especially when you juxtapose that with the utilization of gaming establishments in furtherance of these criminal activities. And I think we have an obligation to do what we can to protect women against violence and minors from sex trafficking. And I think this is a prime candidate for exclusion. And I've listened to the presentation today. It's been very helpful from everyone. I know there's been a great deal of work that's gone into this. This is unusual, but I think we have to be apprised of what's happening in our state and respond accordingly and send a message. Thank you for your time.
Do you have any comments?
I don't have anything more to add. Again, I mean, anything that we can do to support the industry and Metro in keeping these bad actors out of casinos, I think is worthwhile and something that I would fully support.
Okay, so before, I would just reiterate my position, which is I don't disagree with anything anybody said up here today as far as concerns. I certainly respect Metro and the job they have to do, the licensees and their incredibly difficult job in dealing with the trespass laws that are so frustrating. My only, I'm going to vote to support this, but my only caution would be, I would hate to see this used as a mechanism to circumvent an inability to prosecute for a prostitution. That's not what this is supposed to be. It's not, let's go to the place with the lesser standard where they take a lot of hearsay. Right? And with that said, all in favor of the motion, say aye.
Aye.
Any opposed? There are none opposed. Thank you.
Thank you, commissioners, and I'll have an order for you to sign, Madam Chair.
Thanks. Okay. Oh, I thought Mike was doing it. All right, Madam Secretary, next agenda item, please.
You have 3 regulation agenda items regarding proposed amendments to Nevada Gaming Commission Regulations 5, 6, and 29 as noted on the agenda.
Madam
Could you
Chair,
state your appearance again?
members of the commission, Madam Secretary, Mike Somps again for the record. I'm sure you're tired of hearing from me today, but today you have on your agenda some proposed changes to regs 5, 6, and 29. The proposed changes to regs 6 and 29 are contained in drafts dated June 15th of 2022. The changes to reg 5 are contained in a draft dated July 13th, 2022. These drafts have been posted to the board's website for some time now. I'm not aware that any public comment has come in on these proposed changes. I can tell you that I went through all these changes with the board back in July at its meeting. There wasn't anything controversial. Really what we're doing, this comes out of the Tax and License Division, and we're mainly just cleaning up and modifying some of these regulations. I can go through them again in detail if you'd like. Otherwise, I'm happy to answer any questions. Again, we're looking. Go ahead.
Unless the commissioner specifically asks you to do that, I don't think that would be necessary. Thank you for the offer, though. I appreciate it. Does anyone have a motion?
Madam Chair, I move for approval of the proposed regulation amendments to Regulation 5, Regulation 6, and Regulation 29. The proposed changes to Regulation 6 and 29 are dated June 15, 2022. The proposed changes to Regulation 5 are dated July 13, 2022. And I would move to have those be effective upon passing.
Yes, please.
Thank you.
Okay, any questions or discussion on the motion? Okay, there being none, all in favor say aye.
Aye.
And there are none opposed. Thank you.
Thank you.
Thank you.
Okay, at this time, we have our next agenda item, please, Madam Secretary.
This informational item has been placed on the agenda in accordance with NRS 434.00814A, which requires the board to solicit public comment on the draft of the commission's language access plan.
Okay, I'll first go to Carson City. Anyone wishing to make a public comment? Present? I can't see, I'm sorry. No, okay. It appears that there's no one present in Carson City to make a public comment. And it doesn't appear anyone stepped forward here in Las Vegas to make a public comment, so that will close our informational item. Next on our agenda, excuse me, are the administrative reports. Let's start with Chair Gibson.
I don't have the details of the numbers of restricted. Okay, we've got 12 non-restricted items, 14 restricted, and a new game, and it'll be the September 7th, starting at 9 o'clock. Thank you very much.
Thank you. Madam Secretary, let's close. Anything from the Attorney General's office today?
Nothing today, Chair. Thank you.
Thank you. Okay, so Madam Secretary, if we could close with our last agenda item, public comments.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters.
Going to Carson City, anyone present to make public comment? There appearing to be no one. Here in Las Vegas, there also appears to be no one to make public comment at this time. So this concludes the Nevada Gaming Commission meeting for the month of August. We are adjourned. Thank you.